Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand? Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. So. And it's
I'm not a person, I'm one of the people, thank you.
Okay, thank you.
There we have it. In celebration of what we have coming up today, we have a little pro se soundbite from the archives there this morning. We've got a pro se doubleheader today to bring you. It's an interesting one. I'll tell you now, 80s Music Man would get his workout with the edit button. It might have some language in the body cam. By might, I mean it definitely does. Like 100% have a lot of language in the body cam. That's coming up. It's a little gem. Thank you very much for the tip, by the way, on this one. Let's see. It's a beautiful day. Happy Thursday. Happy Thursday. My hair is on point, apparently. I just barely combed it. Like, just barely. What happens is, like, 3 minutes from now, I'm going to adjust my headset without thinking, and it's going to just mess up my hair, and it's going to be ruined for the rest of the day. But right now, it's perfect. Well, at least it's in order. It's not perfect. It's the best I could do in about 30 seconds. Can't see chats on the screen. What about this one? Just kidding. You can see it now. Welcome this morning to Sharon McDonald, first in chat today. Sharon, congratulations. One of our fantastic mods. You all know her. She's amazing. First one in chat. She says, am I the only one here? No, you're just the first one here. Everyone else was being quiet, Sharon. They were enjoying the stillness of the morning. It was peaceful. We were doing some deep breathing. It was...
Is that correct?
It was calm. It was quiet. We had the whole day ahead of us with like literally no pressures on our shoulders. We were contemplating all the possibilities that could be. Daydreaming a little bit. Just enjoying the stillness and the peace and letting it just seep through our bodies when out of nowhere you came in and said, am I the only one here, Sharon? No, just kidding. Sharon, thank you so much for being first in chat. We appreciate you very much because without you, no one else could have talked today. Without you, no one else could have talked. And we are glad you broke the ice. Thank you very much. I thought it was always a hidden rule that mods couldn't win the internet. Usually mods are busy on other stuff, so it's for them to be able to win the internet as well. That's just impressive. They're gearing up for doing their pre-show pep talks and things like that. So, all right, so we're going to now wake up everybody. I'm sorry about the music; it put you to sleep. We'll have to do some. See what's a good intro to wake people up. This one is. Good morning, everybody. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you for joining me today. Today we have bad behavior in court. What happens? What happens when someone just can't behave? Well, first of all, they can't behave in front of the police officer, and it gets caught on a body cam. And guess what? When you go to court, guess what? It gets shown in court. That body cam. We're going to see that today. We've got a double header with the pro se defendant. Is that a little better? Is everybody awake now? Okay. I'm excited. We have so many things to go over this morning. Also, we've got, I was just looking at the news. The docket just posted on Twitter. There's a couple guys, I guess, in the last Delphi hearing that sort of were acting up in court. One guy was acting up in court, and then they took it to the hall, and they were acting up, and they're like, hey, guys, calm down. And they went downstairs, and they're acting up and yelling at each other, and they're like, hey, take it outside. And they went outside, and they were acting up again. Well, the judge has now banned them from all the proceedings for the rest of this trial, the Delphi trial. And they're named as well. I'm not going to out their names because obviously you can find them. But yeah, apparently don't behave badly in court as a spectator either. No Mountain Dew this morning. No Mountain Dew. I did go get some cat food, if that, I mean, it's not for me, but the cat appreciated it. So let's see. We have, there was YouTubers' bad behavior in court. We had some of that. I'm not going to go into that. We have some birthdays and anniversaries to celebrate, which is what we do now. Let's see. Buffer Bug Dugger had the 31st anniversary. Congratulations. Laura, Ivan Victor, Huntley, a dog, 5 today, all celebrating their special day with us. Happy birthday, everybody. Let's sing happy birthday to Laura, Ivan, our very own Ivan, and Huntley. Good dog. Who's a good boy? Is it a boy? I guess it's a boy. Who's a good boy? Okay, we're going to sing to all of them. Warm up with me, please. La, 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 la. All right, we're ready, dancers. Nosy Rosie is in charge. Follow the lead. Remember the new steps you've practiced. Okay, here we go. Everybody, together, all right? Red pen, great idea to stretch. You don't want to pull anything before the weekend. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Laura, Ivan, and Huntley. Happy birthday to you. For all those who are having birthdays today, Laura, Ivan, and Huntley, I hope you have a very special day. Ivan, I hope today goes well for you. I hope it's fantastic. I hope all your wildest dreams come true. And a thumbs up. That's all I got. Laura as well. Huntley, Laura, I hope you have a great day. I hope you get free pancakes. Ivan, I hope you don't get free pancakes. No, Ivan and I have talked, so he knows what I meant. Huntley, I hope you get like head scratches and pats and a new dog bone. If I was standing on direct, I would go boop, and all that would happen. But I'm not the goddess of true crime, so I cannot do that. All right, happy birthday, everyone! Thank you very much. Let's see, we have wow, and on your birthday, Amy Manty, 12 great months, has celebrated her anniversary of membership on the channel. Thank you, Amy. Thank you for 12 fantastic months. Congratulations on that orange courthouse as well. We sounded amazing this morning. It was just good. It was just good. Dancers looked great. I'm not RA. What? What did I say I'm not? Kayla, thank you for the kind words. Appreciate it. Wow, I got all the names right. Wow, impressive. There were only 3, though. We've had days that we've had a lot more birthdays. You know what today is, in addition to your birthdays? Ivan, Laura, Huntley. It's podcast day. So we have a podcast tonight. Thomas and I have a great stuff, and I found a funny story I have to talk about tonight as well. So we'll put that on the non-agenda. All right. I think the song's almost over. Should we stick around for the big finish? I see the dancers are still going, so I guess we can't turn the sound off. Ready? There we go. Air drums for the big finish. All right, we are... This is a message. What caused this? This is a message. In case you doubted, now you know. All right, Huntley loved it. Great to hear, Crunchy Frog. It's my brother's birthday. Dusty Den, happy birthday to your brother. It is Friday Eve. Oh, it is Friday Eve. Podcast day. Ivan, have a great day. I'm not sure if he's in chat yet. He's got some stuff going on this morning. So, all right. That said, here we go. Let's do this. Let's tell you. We have a pro se case that happened just this week, and it's tiny. It's a Zoom court. The audio is better. It has body cam footage, which we will see. But it's Zoom, and it's a 4-box Zoom with 2 boxes, so it's not the best, but I can zoom in. I don't know. We'll see what we do. Let's see. No updates on the Idaho manhunt that I know of. He's still missing. They have not caught him. By now, he could be in either Canada or Texas, or most of the way to the East Coast. I don't think he could make it all the way to the East Coast yet, unless he caught on a plane, which I don't think he's done. I believe he's going to be driving and wherever he's going. So Mexico or Canada are probably the preferable destinations, and I'm guessing south. We're done from the trial from yesterday. 7. We did bail on the trial from yesterday, and I owe a huge thank you to everyone who worked on the thumbnail, who slaved away on the thumbnail as we bailed after 2 days. 1 day of court, but 2 days of video packed into 1 day of viewing. The audio was just terrible. It was terrible, terrible, terrible. And we voted. It was 60-40, and we voted to go ahead and move on to another trial. So we'll do that. So yeah, the manhunt and his accomplice, both missing. Justin says today's my daughter Audrey's birthday. Audrey, happy 6th birthday. Happy 6th birthday. That's a big 6. Do you know what you get on your birthday when you turn 6? Anything you want. Pony, you name. No, sorry, Justin. Hope she's not listening to hear that. 6 is a fun birthday. It's just fun. Happy birthday, Audrey. All right. We have, let's see, your birthday song every morning makes my day great. It's not even my birthday, says Hazelnut Pretzel. Well, thank you for singing and joining with me. I appreciate that. What was the outcome of the trial? Jamie, here's what I can tell you. In the opening statements, the prosecution said you're going to see on video the defendant commit these crimes. And then we're going to prove it forensically as well. And this is not a beyond reasonable doubt. This is beyond all doubt. They said there is no doubt that this is what happened. We will 100% prove this. And then the defense team got up on their opening statement and said, they're right. Yep, he did it. You're going to see it. So it's not a question of whether or not he's guilty. Okay. The defense just says, we think he's guilty, but we don't think you should kill him for it. Meaning we don't think he should get the death penalty. That's all it is. So I'll go ahead and spoil it for us because they already spoiled it in the opening. He's guilty. He's guilty. I don't know what the sentencing is because I didn't watch that far. I like to watch. I like the surprise too. So we might have, you guys are okay with spoilers. I doubt many of you want to listen through that painful ear experience to hear it. But if you do, it's over there on Judge Wolf's case. We'll leave it, and I won't spoil it for you here. So it's on Judge Wolf's YouTube channel. Go back to what is it? 8th month of 2021 was where it happened. And there's like 2 segments. It covers about 10 days of trial because there's the first segment and then they have the second segment of the trial for the sentencing. So it's a long one. Let's see. We have, can be here for a few hours going to a disgusting food museum. Disgusting food museum. I didn't know they had those. Is disgusting food museum part of the title, or it's a disgusting food museum? I'm curious as to if they actually said, I've got an idea. Let's build a disgusting food museum. And odds are I've probably eaten some of it. Okay, let's. What do we want to start with? Do you want to start with some of the Alec Baldwin stuff? Alec Baldwin, there was a huge document dump the other day, meaning that they just showed up. I think that's just when they were filed. And this was hundreds of pages. And I've just barely started perusing this, and I wanted to share just a couple things because there's, they are limited to, I think it's 40 pages per filing. And so they're like, here's part 1, part 2, part 3, all the way up through like 10 or 11 parts of, 700 plus pages, says Sierra. 700 pages. Hannah Gutierrez got her sentencing delayed because of that motion. We'll see if it works. That motion still might be struck down, and then sentencing will come back on. So, but with all these pages, there's tons of stuff. So I'm scrolling through and finding stuff. I found a couple little gems I wanted to share with you. There is so much more. We could spend days just flipping through because it's like everything they've filed since the middle part of last year, okay, 2023, which was under the original charges before those got dropped. All of those all got sort of wrapped up into a big exhibit and then refiled. And let me show you just a tiny bit. The first one. First thing I came across, there was a filing in November of 2023 that was a request for sanctions on the state for violating the gag order. Okay, and this will probably still be in place. And the sanctions on the state, when you think sanctions on the state in a civil case, there's like money damages back and forth, right? And that, I guess you could still do that. I guess the state could fine the state and it would go from one budget to another. I don't think that would be very effective. Typically what we see in a court case where there's a sanction, think of Lori Vallow. The prosecutors were sanctioned there, and that took death penalty off the table in her case. So that was one of the sanctions. It's like, all right, now you can't go for the ultimate punishment because you broke this rule, discovery rule, I believe. And so in this case, Alec Baldwin is saying in the filing, they're saying that the prosecutors broke the gag order, and within 1 hour of the gag order coming out, they were like on the television and doing this press release and doing a big show. Hey, check us out on Facebook. We're going to do this live, and it's just all sorts of stuff. There's big problems there, and so he's saying that the court should also impose additional sanctions that it believes to be just and proper in the circumstances because monetary sanctions are not adequate to remedy the harm. The state should not be permitted to buy its way out of trouble for conduct that previously caused Baldwin prejudice by disclosing information about the grand jury process or for continuing to cause such harm by violating the court's November 15th order. New Mexico courts apply severe remedies to address prosecutorial misconduct. That's a big word. The law in New Mexico recognizes that a court can dismiss criminal charges based on severe prosecutorial misconduct. So they just inject it in there. By the way, you can even throw out the case, Judge, if you'd like, just to punish them, because they really shouldn't do that. They were bad people if they broke the gag order. So that was the one. Let me tell you this other one that was hilarious that I found. There's an emailed letter of resignation from the lead investigator to the prosecutor. Okay, so the lead investigator is quitting, and in the letter he's basically saying, okay, per our agreement, I'm quitting. Okay, and it's almost worded like there's a gag order where he's signed a non-disclosure or something, which I've never heard of before, and it's mentioned here that that's unheard of to have a prosecutor sign a non-disclosure agreement as they leave a case, but. So in his letter, he says, in accordance with the agreement entered into between you, your office, and myself, specifically item numbered 6, please accept this notice of termination of our agreement effective July 5th of 2023. And then towards the end of the letter, at the very end, when he's like, okay, I'm going to continue. I'll be on for 14 days. We'll do a seamless transition. I'll pass everything over and let everyone know where we're at and just turn it over to your new team who's going to investigate. And then he says, but I have to say this at the end. Ready? The conduct of the Santa Fe County Sheriff's Office during and after their initial investigation is reprehensible and unprofessional to a degree that I still have no words for. This is the lead investigator for the prosecution in the Baldwin case at the time. Not I or 200 more proficient investigators that I can/could clean then I can or could clean up the mess delivered to your office in October of 2022, 1 year since the initial incident. Inexcusable. It was an honor to be considered and selected to assist in this investigation, an investigation of the preventable, recklessly caused, and ultimately untimely death of Miss Hutchins. Then he made a mistake because this resignation letter was sent by email. And he was supposed to send it to the prosecutor and a couple people on her team. It was supposed to be copied to Jason Lewis. Jason Lewis, you were supposed to get a copy of this resignation letter. Unfortunately, when he put Jason in and then hit tab, it auto-corrected to the first person on the list with the name of Jason, who was Jason Bowles. Who was Jason Bowles? Well, Jason Bowles was Hannah's attorney. Hannah's attorney. So Hannah's attorney gets a copy of this resignation letter with the gripes and complaints of the investigator, and then it's followed up by an email from the lead prosecutor to Jason Bowles, who says, quite in a very, very short email, Jason, Rob's email to you was intended for Jason Lewis. It was an inadvertent disclosure. Please delete it. Thank you, Carrie Morrissey. Oops. It shouldn't have. You shouldn't have seen that internal turmoil that's going on. Okay, this is just where I'm just starting to scratch the surface of all the documents that are in this. I mean, we've got 700 pages of stuff, and it's everything. So most of this will probably not come out in court. There's a lot of arguing about sort of the bickering back and forth between the two teams, the prosecution and defense, about how they move forward. And it's like, well, you should have just talked to me, and then you wouldn't have had to file this motion in court. And, well, you didn't respond when I did this. Well, you only gave us 5 hours. And it's a lot of me, back and forth between the two sides, back and forth. So it's just crazy. I'm going to keep looking through this. I think this is going to be my light reading for the weekend, I think. But just know that as this gets closer and closer to happening, they're putting on a very strong defense, and they're firing all guns. I mean, that's probably a bad example, analogy. They're attempting every avenue available to them to either have the charges thrown out, have them lessened, have the sanctions put on, basically anything. Where can I get the document? Let me give this to you, because you guys will do a better job tearing into this than I can, because it's 700 pages. I can't read it all. The way it goes like this. I'm going to put if you give me just 1 minute, I'm going to put a address. Okay, if you go to, I think this works, www.nmcourts.gov, and you guys, I'll walk you through this if you can open this in a new window. Oh, that link didn't work, did it? Hang on 1 second. Oh, let's do it this way. Sorry, guys. I'll do it a different way here for you. View my channel. There we are. Let me mute myself. Okay. Paste it here. Okay, there's a link that you should be able to click on, I think. There it is. No www. So NM Courts. You click on this link right here, and it will get you to a page. I'll walk you through it, because they've sort of hid this. They've hid this, and you don't have to do a document request. That's the cool thing about this. They've posted all these online if you go the right direction, and you don't have to dig for it. So let's see, New Mexico courts. Okay, so on this main page, let me drag this over so you can see where I am as well. Let's go right here. Okay, so you should be on this page, right? Once you get here, go up to the little button on the top that says News, and click on News. Then go down to High Profile Cases. And under High Profile Cases, we're going to look at the State v. Alexander Ray Baldwin, the new one, not the old one. This is the closed one where they initially filed the charges and dropped them. You've also got Hannah Gutierrez in there, but you can go right here to the new document. You expand this, and you look at these filings, and you look at everything that came in on March 14th, right? Motion to exceed page limit. Motion to exceed page limit. Unopposed motion to exceed page limit. They say Baldwin intends to file a motion to dismiss the indictment in this matter, which is currently 52 pages long due to the length and breadth of relevant information necessary for the court's consideration. So they're going to have a longer motion. But all these, so that motion, oops, I closed the wrong thing. Let's see, let's go back to, well, I closed it completely. Anyway, so once you get to the New Mexico courts page, go to the news button and then go to the high profile cases, and you can look at either the Hannah Gutierrez one if you want to see the latest filings there, or the Alec Baldwin one, and either one you can click on. It will just bring up a PDF that will show you all those pages, and you can read to your heart's content. Can we see the Maya counter? There it is. Maya counter is right here. Let me turn my picture off so you can see. We're up to 3 million. Well, I think today we're going to hit 3,200,000. So we might hit 3210, and then maybe 123. So we could get one of those countdown, count back ups. Maybe someone might be able to catch 3210, 123. on the counter with a screenshot. That would be really cool. But yeah, we did pass $3 million about 3 or 4 days ago. So, all right. Anyway, loads of stuff. There's tons of good reading there. And please, if you find something in the Alec Baldwin files that are interesting, that are telling, or it's just like, wow, here's a gem. Send me a text on the burner phone. Just a little synopsis, and then maybe a link to which of the 10 or so different batches of documents it's in. That would help me find it that way. All right. I would do all my communications with that prosecutor by motions too. She is horrible, says rejected juror. Yeah, she's a bit to work with, and there's some complaints. They're not fond of each other. All right, let's see. What else do we have? We want all the spice. There's so much reading there. There's so much good stuff. And going into Hannah Gutierrez, I think it has in there the latest filing they have on their motion and why the sentencing is delayed. Anything new on the Idaho escape? No, it's getting a little more press nationally. You're going to see that a bigger story now. I will tell you that if they got in the car and beat it out of town, out of Boise, by now they could be down through Texas. They could be obviously to California, up to Canada is obviously an option. 24 hours. Where can you go in 24 hours? A lot of driving. You could get almost to the East Coast. You're midway across the country, depending on when you rest and stop and eat and things like that. So it's the manhunt has to be expanding a little bit. This isn't something they can just put a net around and say don't let anyone leave this area, and they're in a car, or they were in a vehicle that is very common. It's a very very frequently viewed vehicle, and so it's hard to pick them out of a crowd. What's probably going to be the most effective now is if they are able to identify that vehicle by a license plate or some sort of unique identifier. Either that will be cited and turned in, or it will their next time that they will be seen is when they are committing some sort of a violation, whether it's a speeding offense, which is what a lot of people do, they speed, whether it's another crime of opportunity where they either need money or need another vehicle, or need a place to stay or need food or something. What if they have a need for something like that to continue their run, and it's when they run into somebody else, that's when we're probably going to get the next report. So they're probably going to be watching for other stolen cars if they switch vehicles. They're going to be watching for, you can have bank robberies when people are on the run. You can have these random occurrences out of nowhere. People get robbed or their vehicles hijacked and things like that. So those are the sorts of things I'm sure the investigators are keeping an eye on. Let's see. What else? I haven't followed the Riley Strain search. Was he the one that was walking down by the river and went missing? They found his debit card. Is that the same one, or is this a different search? I think the young man might have been intoxicated. I think the going theory in that case, if that's the same case, was that he possibly fell in the river. Hazelnut says, I get on here in the morning and you help start the rabbit hole for the day. You're a bad influence. Just kidding. I think I have ADHD. Well, let me tell you, we have, yes, that is the one. Okay. So I followed that a little bit. I haven't followed it closely. He just disappeared. Vermillionaire, I do see the Timothy Verrill trial going on. I think they're calling that the Small Town Murders over on Court TV. It's bad. We're not going to pick up that trial at this time. We have some others that I think that will overlap with the starting date. My nose itches. Like I went outside today and I saw all the pollen. Like I went to put gas in the car, and the gas pump, which is normally like a black rubberized plastic, was like yellow with pollen. There's just so much pollen everywhere, and now it's catching up to me. All right, let's see. It was TikTokers who found his debit card. Wow, that is fascinating. I love it when the authorities can't. I'd like it for the authorities to find all the information, but I love it when people are able to help out, legitimately help out, especially if it doesn't impede the investigation in some way. Ryan Applesnapple, I still have Mrs. R.A.'s duck and my duck next to each other right here. They're a matched pair. I think we're going to try to name my duck officially on the podcast tonight. Mrs. R.A., she has not named her duck. She's not an animal person, but I think it's a beautiful duck. So we'll see. All right. Let's see. Gossip rumor in India. No, Kathy. Riley had a drunk fall into the river. In my opinion, I think you're right. I think that is. I mean, there's obviously opportunity for something else to happen, and the way the news is telling the story about, you know, a friend should have gone with him and things, man, it's just pouring, you know, blame on somebody who just made a decision. It's like, oh, I'm going to stick around for a while. I'm not leaving right now. His friend was drunk and was leaving. Probably would have been better if they had left with him, but man, that was on a simple decision like that. That's not a crime, but you can't blame him for something going wrong like that. All right. Ari, I bought a screaming goat for my nerves. Hope it arrives today. Love it. Love the screaming goat. Tribute to Law Talk with Mike. All right. Speaking of Law Talk with Mike, he might pick up this case that we're going to air today. Or should we jump to that, or do we want to? Yeah, let's do that next. Let's do this. Here's my plan. We have about, it's under 2 hours of video from this case that just barely happened. It's a court case. It's been very much under the radar. Let me see. I'm trying to remember. I don't remember where it's coming from. Hold tight. Let me find this. I'm just excited to be here today. Okay. There we go. Grooming time, by the way. Thank you very much for the tip on this one. Indiana court. This is out of Indiana. And it's Elkhart Court. Elkhart Court out of Indiana is where this is coming from. So let's go over here to this. And it's not going to be on that one. It's going to be on my player instead. And let me warn you. Buckle up. There's some language, not just some language. Imagine, I'm not sure if there's any intoxication involved, but imagine a very drunk, angry sailor using all the words. That's what we're going to get. A drunk, angry, and I believe a little bit racist is in there as well. I haven't listened to the entire thing, but I think there was a little bit in there that is beyond just cursing. So we're gonna give this a go and see just what the law does to him as a result.
Good morning, everyone. You may all be seated.
Defendant is in tan shirt.
Moment to start my video for those online. All right, folks, we are here for the bench trial in the case of State versus Paul J. Miller. This morning's case is regarding the felony, and that's cause number 20-DO5-2204 F6 500. I'll show that Paul J. Miller appears in person in open court. Mr. Swaby appears in person for the state, and just confirming some prior items that we covered in court. Mr. Miller had indicated on multiple occasions he would like to represent himself, so he is here without counsel. Mr. Miller, are you still wanting to represent yourself?
Correct.
Correct. Okay, thank you. Just so that you know, sir, I do have Mr. Ethan Legg from the Public Defender's Office in court. He is not your attorney at the moment. You are representing yourself. But if you should ever change your mind during the course of today's proceedings, all you need to do is let me know, and we would be able to have a licensed attorney by your side, okay? Do you understand that, sir?
Yes, I understand.
Okay, excellent. So the way this morning will work is the state has the burden of proof, so it will be able to call its witnesses first. The state is able to give an opening statement before calling witnesses. Mr. Miller, you can also give an opening statement for everybody's knowledge. An opening statement is not an argument or what you would see in a closing argument, but it is more a foreshadowing of what evidence each side expects to be seen at the trial. So with that being said, Mr. Swaby, does the state wish to make an opening statement?
No, Your Honor, state related.
Okay. Mr. Miller, would you like to make an opening statement?
I'm claiming my Fifth Amendment rights not to be put in jeopardy by myself, and I am not, I'm pleading not guilty.
Yes, and we have your plea of not guilty noted, and you certainly do have a Fifth Amendment right not to incriminate yourself and to remain silent during these proceedings. That being said, I'll allow Mr. Swaby to call the state's first witness.
Thank you, Your Honor. State call is Corey Oswald.
Mr. Oswald, will you please raise your right hand? I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, you may have a seat, and if you would then please state your full legal name and spell it for the record, that would be wonderful.
Yes, sir. My name is Corporal Corey Oswald. It's Coryooswald.
Okay, Mr. Swaby, you may question your witness.
Thank you, Corporal Oswald. Who do you work for?
The Elkhart County Sheriff's Office.
How long have you worked for the Sheriff's Office?
Approximately 13 years in March. Be 3 years of corrections, 9 years of patrol.
Okay, did you go through training to become a police officer?
Yes, sir, I did.
Just generally speaking, what was that training? Where'd you go? How long was it?
I went to the Indiana Law Enforcement Academy. At the time, it was 15 weeks long. And then after that, I came back to the agency and did a 3-month-long FTO process.
Okay. What does FTO mean?
Field training officer.
Okay, and what does that entail?
Hands-on experience training. And then if there's any other remedial training that needs to be done, it can be done kind of outside of the hands-on environment.
Okay, so on-the-job training?
Yes, sir.
If you will. What are some of your responsibilities as a police officer at the Sheriff's Office? For you specifically?
For me, I'm an assistant shift commander, so I kind of oversee the shift, kind of help the shift commander with any sort of administrative paperwork. I also manage calls for service and then proactively do patrols looking for active crimes, so forth.
Okay. Sir, I want to take your attention back to April 19th of 2022, so almost a year and a half ago. At that time, were you working as a sheriff or working as a police officer for the Sheriff's Office?
Yes, sir, I was.
Okay. And were you specifically working on that day as a police officer for the Sheriff's Office?
Yes, sir, I was.
Did you have a chance to go out to an address of 51619 East County Line Road that particular day?
Yes, sir, I did.
Okay. Can you explain why did you go out there that day?
We were given information of an individual by the name of Paul Miller having an active arrest warrant. So we and a couple other individuals had gone out to serve that arrest warrant.
Okay. Do you recall who else was with you?
It was my Sergeant Leaper and our K-9 unit, Sterling.
Okay. Can you, and so ultimately you guys did make it out to that address on East County Line Road?
Yes, sir, we did.
Okay. This particular address, is it located in Elkhart County, state of Indiana?
Yes, sir, it is.
Okay. So can you explain what happened when you first got there? What did you observe? What happened?
Sure. So my task was the less lethal operator with the pepper ball system. The address that you had mentioned is more of like a red barn style duplex. There's apartments kind of spread throughout the residence. We had parked on an alley and made an approach from the south northbound. We didn't know exactly what apartment we were going to, so we began knocking on an apartment. At that point, I saw a male subject who I was able to identify as Paul Miller walking from the north-southbound. He was verbally yelling at our K-9 unit,
okay.
At which point, sorry.
It's okay. I want to stop you there real quick. You're saying a lot. Why did you noted that you were in charge of having a least lethal, I forget how you phrased it, but you had less lethal kind of operation there, and you said it was a paintball?
Pepper ball.
Pepper ball.
Yes, sir.
Why did you guys feel the need at that point in time to have that ready and available?
We had gotten an email from one of our county employees that Mr. Miller had made threats towards that employee.
Okay, so it's for safety?
Yes, sir.
Okay. And so you said you noted you observed somebody walking towards you guys?
Yes, he was coming down a dirt road from the north-southbound.
Okay. And what happened as this guy approached you?
He was yelling at our K-9 officer, at which point I gave verbal commands to Mr. Miller, and he turned his attention to me.
Okay, so this, I want to just make sure we connect the dots here. This male that you said was approaching from northbound?
Yes, sir. He was
Paul Miller?
He was he was coming from the north-southbound. And
okay.
I was able to identify him as Paul Miller.
Okay, perfect. And when you say Paul Miller, is Paul Miller in the courtroom today?
Yes, sir, he is.
Can you point to him, identify by something that he's wearing?
He's sitting at the defense table wearing a tan shirt, button-up shirt.
Your Honor, please let the record reflect the in-court identification of the defendant.
The record shall so reflect.
Okay, so Paul Miller's approaching you. He's yelling at Officer Sterling. You didn't get his attention by...
I gave verbal commands for him to put his hands behind his back, and I had the pepper ball at a low ready.
Okay, and can you explain what that means?
I'm not pointing it directly at him, but it's kind of a quick snap that I could be on target if needed.
Okay, so it's out, you're not pointing it at him, it's pointed downward?
Yeah, at a downward angle, yeah.
At a downward angle, okay. So what happened next?
At that point, Mr. Miller turned his attention towards us. Again, I gave him verbal commands to put his hands behind his back, at which point he complied, but he was still being verbally aggressive towards us.
Okay. What do you mean by that?
Yelling, he had made a statement.
Okay. What kind of statement did he make?
He had told us that all law enforcement officers had a death warrant.
Okay. How did you interpret that?
A law enforcement officer having a department-issued uniform clearly placed visible patches, and that we all had a death warrant. Anybody who was...
I object to that.
On what grounds, Mr. Miller?
It was not said. He's not saying the truth.
Okay. Your response, Mr. Swaby?
Well, Your Honor, that's it's a factual dispute. It's an improper objection. That is a factual dispute. If Mr. Miller wants to dispute that and try to impeach the witness, he may do so on cross-examination or through his own testimony.
Okay. Based on the grounds stated, I will overrule the objection and I'll allow the answer, and you may continue to testify.
And I also have another case, Paul Miller versus Kosciuszko Zoning Appeals, Superior Court 1, Warsaw, Indiana. They've been sued on a prior case. So, and you have also. So,
Mr. Miller, those are irrelevant to today's proceedings. So,
just so I wanted to notify it so you guys have notice of it.
I believe, at least for my part, I responded to that lawsuit you filed against me and answered it, and we're not going to get into that on today's proceedings. Mr. Swaby, you may continue.
Okay. Corporal Oswald, you were, I believe you were answering my last question of, how or if at all did you interpret that statement by the defendant?
Yes, I just felt like he was grouping us all in the statement when he said that we all had a death warrant.
Mm-hmm. Okay, and so what happened after, so you recall specifically at what point in time he made this statement? So let me backtrack. You asked him, directed him to comply and be put in handcuffs. You said that he did comply and was put in handcuffs.
Yes, sir.
Do you recall at what point, after you put him in handcuffs, was he taken to a patrol vehicle?
He was, yes, sir.
Okay, do you recall whose vehicle?
Sergeant Leapers.
Okay. And you recall at what point in time, did he make the statement before he got into the vehicle?
Yes, sir, he did.
Okay. Do you recall about where at?
I don't recall exactly where. I just know it was as we were walking to the patrol vehicle.
Okay. And then did he ultimately get placed into Sergeant Leaper's vehicle?
Yes, sir, he did.
Okay. And did you, I guess at this point in time, did you have any other involvement in this case?
No, sir.
Okay. No further questions, Your Honor.
All right. Mr. Miller, you may question Corporal Oswald at this time, but just to be clear, this is only a time to ask questions and not to testify. You would have that opportunity later if you chose to testify. Do you have any questions for Corporal Oswald?
Do you know that you've been sued in a prior case, Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana? Precedent to this, do you know that you've been sued?
No, sir. Checked on relevance, Your Honor.
Okay. Any response to the objection on relevance, Mr. Miller?
Not at the present time.
Okay, then I will sustain the objection, and Corporal Oswald, you do not need to answer that question. Mr. Miller, you may ask another question.
That's all I've got.
Okay. Any redirect by the state?
No, Your Honor. The state would ask Corporal Oswald to remain in the courtroom, not to be released from the subpoena.
All right. Well, at this time, Corporal Oswald, you may step down from the witness stand, but you are not released from your subpoena. If you will stick around in the courthouse, we would appreciate it.
Thank you, sir.
Thank you. And now the state may call its next witness.
State calls Adam Leeper.
All right, Sergeant Leeper, if you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God? You may have a seat, and then if you kindly state your full legal name and spell it for the record, that would be great.
My name is Adam Leeper, Adamleeper.
Thank you, sir. Mr. Slavey, you may question your witness.
Thank you. Sergeant Leeper, what do you do for a living?
I work for the Elkhart County Sheriff's Office in the Patrol Division.
How long?
A little over 16 years.
Did you go through training to become a police officer, sir?
I did.
And what was that training?
It was the Indiana Law Enforcement Academy. I went through in 2007, 15-week training course, and then graduated from there. And then went through the field training program at the Elkhart County Sheriff's Office for 3 months.
Okay. I want to get straight to it, sir. I want to draw your attention back to April 19th of 2022. On that day, were you working as an officer at the Sheriff's Office?
I was.
Okay. And did you guys happen to have a call out at 51619 East County Line Road that you would have responded to on that day?
Yes, we responded there to attempt to serve an arrest warrant for Paul Miller.
For Paul Miller, okay. And that address specifically, that property, that located in Elkhart County, state of Indiana?
Yes, it is.
Okay. So, and you ultimately did respond to the address physically? Like you actually went there?
Yes.
Can you explain to the court initially what happened? What did you observe?
When we arrived at the residence, I was there with Corporal Oswald and Patrolman Sterling. We went up to the address. There's several apartments in the building, and we didn't know for sure which apartment we were going to, so we were going to just honestly start knocking on doors trying to locate Mr. Miller. And then as we were knocking on one of the doors, we saw him walking southbound on the dirt road. And we were able to identify him at that point in time just from visual sight.
Okay. You knew what he looked like before heading in?
Yes.
Okay. Is that because you had looked at a photo of him to prepare for the search, serving the warrant, or had you had prior interactions with him?
Both.
Both?
Yes.
Okay. And so you observed, and when you say Paul Miller, is that Paul Miller that you were out there that day with to see in the courtroom?
Yes, he is.
Can you identify him by noting where he's sitting and an article of clothing that he's wearing?
Yes, he's sitting at the defendant's table wearing a tan button-down shirt and blue jeans.
You want to please let the record reflect the in-court identification of the defendant?
The record shall so reflect.
Sergeant Leeper, can you please explain, so as Paul Miller was approaching, what happened? Can you tell us that?
Sure. As he was approaching, myself and Corporal Oswald approached him. Corporal Oswald had a pepper ball gun out. He began to give him commands to put his hands behind his back, and he cooperated with that, and I put handcuffs on him, got him into custody.
Okay. And you say you took him into custody. What happened after you put him in handcuffs?
Once we put him in handcuffs, he started saying things about how we didn't have a right to do that. I read the arrest warrant to him, letting him know what we were arresting him for. He tried to tell us that wasn't valid, and said that he had a death warrant out on all law enforcement.
Okay. And is that, again, prior to him being placed into, was he being put into your car?
Yes, he was being put in my car.
Okay. He ultimately was placed into your car?
He was.
Okay. And those statements, was that made outside of the vehicle?
Yes,
it was
the vehicle.
Okay. So, although he's making these statements, is he physically cooperating with you?
He was physically cooperating, yes.
Okay. He was just verbally disagreeing with what was going on?
Correct.
And then making that statement about officers having a death warrant?
Correct.
So, did he ultimately get placed into your car?
He did.
Okay. What happened after he was put in your car?
I began transporting him to the Elkhart County Jail for the arrest warrant. And
okay. And is there anything of note that occurred during your transport of the defendant to the Elkhart County Jail?
Yes, on the way there, he was saying a lot of things about how we didn't have a right to arrest him. We didn't have a court order for it. Tried to again explain that I had an arrest warrant for him. And he said that it wasn't valid because he had sued the state of Indiana. He sued the judge, Judge Spataro, and that as a result of me taking him into custody unlawfully, he was going to have the United States Air Force kill me.
Did he say this just once?
No, he said it twice. Actually, 3 times. Well, he said it 2 times and then confirmed it a 3rd time when I asked him, did you just say you're going to have me killed?
Okay, yes. And he said yes to that?
He did.
Okay. Do you have, did your vehicle that you transported the defendant in that day, are you aware if it had video that was playing during your transport?
Yes, it had an in-car camera with a front-facing camera as well as a camera in the on Mr. Miller in the backseat.
Okay. Permission to approach, Your Honor.
You may approach.
You guys, all the spiciness comes in one chunk. It comes in one chunk. We're about to get it right.
Sergeant Leeper, I hand you what's marked State's Exhibit 1. Can you tell me what you have in front of you?
Yes, that is a copy of the in-car camera from my car on that day, that event.
Okay. Have you had a chance to review that specific disc?
I have.
Was that earlier this morning with myself?
Yes.
Is the video that is on there a fair and accurate depiction of how you remember things occurred back on April 19th of 2022?
Yes, it is.
State would move to enter States 1.
Okay. Any objection to the admission of States 1 into evidence, Mr. Miller?
Everything that I was speaking about, that precedent case, I've got a case, Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana. All the sheriff deputies have been sued in that case, every one of them, and they are on execution stay. So they're saying I said a death warrant, and I never mentioned anything about a death warrant. There's a court order that says they're on execution stay in that case, and it's a precedent case to this case. So,
and I understand that, sir. Do you have any legal grounds for an objection to the admission of this exhibit into evidence?
I don't have anything further to say right now.
Okay. Based on what you did say, I will overrule the objection, and I'll allow the State's Exhibit 1 to be admitted into evidence. It is so admitted.
Permission to publish, Your Honor?
You may publish.
Here we go. This might be a good time for the kids to step out of the room.
Can the court still see that?
I can still.
Can you see that, Mr. Miller?
Plug in the HDMI. Fasten seatbelt.
For the record, this video is 1 hour and 12 minutes long. The state is not playing the entire length of the video, only a few minutes of it.
We need a FOIA request for this.
I will be starting the video at 26:10, 26 minutes and 10 seconds.
And I told them the last time that
Indiana, Elkhart County. Here goes the cuss counter. Keep an eye on that.
They told me I was going to the United States Air Forces. I'm going to make them do their job. I own them already.
You own the Air Force?
Shut the fuck up. Don't speak to me dumb like a dumb fucker that sits there radio waving little girls all day long and looks at them. I know what you fuckers do. You're evil. You're not getting away with it anymore. I'm going to deal with the whole state of Indiana just because of you. Get a good look at him, the rest of you in my state of Indiana, because of this fucker here, you're going to be dealt with. You're all going to be on. I'm going to have the whole Air Force of the United States Air Force of the whole world have you killed for attempted murder scheme on me again because of this fucker. So get a good look at him. He's partnering up with the Coonses over in my Kosciuszko area. And this is what they do. And they sit there and talk like they don't know what's going on because they're mentally ill, messed up in their heads. They sit there and radio wave people all day long trying to steal from them. You think radio waves are all it? Let's see if you can get out of them with this. I can tell you're a dunkard. You're related to him. I can tell it in your face. You're evil.
Sergeant Leeper, was this one of those times that you mentioned that he stated that he was going to kill you?
Yes, it was the first time.
Like I say, I've got a court order on it. The whole Elkhart Sheriff Department deputies, every one of them have been sued in that case.
Mr. Miller, I'm going to stop you there. Do you have an objection to any question that's been asked?
Not right now, but I just wanted that to be stated.
Okay, I have heard you, but you cannot interject irrelevant items into this trial. So, Mr. Swaby, you may ask your next question.
Thank you. And for the record, the video was stopped at 27 minutes and 39 seconds. I'm going to restart the video at 34 minutes.
I think that was warm-up.
And 30 seconds.
I think he said Dunkard, like a last name. I think he said there was a resemblance.
You're an evil fucking church guy hiding behind the Bible. Check his head out, guys.
You know, if you can't afford it, or you want to be appointed for you.
I don't need one because you have no case against me.
Sergeant Leeper, I started to play this here. It sounds like are you trying to read him something? Or?
I'm trying to advise those Miranda rights, yes.
Okay. And obviously we're still in the vehicle.
Correct.
Okay.
How do you like that? You gotta have a case first, bitch.
You know, if you answer questions about lawyer president, you tell them right to stop answering anytime.
I own it. Every one of my papers, and they're there. I have the prior court judgment. It's valid. You don't.
I'm just trying to make sure you understand that.
Shut up.
Do you understand that?
You shut the fuck up, bitch.
I'm just trying to ask you a question.
You don't know what you're talking about. You're mentally messed up in the head. Pointing radio waves on my people, and I'm tired of it. I'm gonna have the Air Force deal with you.
What are they gonna do?
They're gonna come get you and have you killed. You're attempted murder scheme on me. I've got a case that says no one can do what you're doing to me right now. You're imprisoning me.
Are you threatening to have me?
It's not a threat, and I've got a court order on you.
So you're gonna have me killed?
Yes, by the United States Air Force, and I'm gonna show everybody what you did to me.
Well, you just got yourself another charge.
What you got, bitch?
Intimidation on an officer.
You have no case against me.
Said you're gonna have me killed.
You gotta have a case first.
You just said you're gonna have me killed.
The court's gonna kill you. I'm gonna have the United States Air Force go after you and kill you for attempted murder scheme on me in front of the whole world. It's not, and they all know it. And I'm gonna tell them when I get it.
You know, notice that I said United States Air Force.
Mr. Miller, it's not time for you to talk.
For the record, the video was stopped at 36 minutes and 20 seconds.
Thank you, Mr. Spear.
Sergeant Leeper, what ultimately happened? Was this the second time that he made those threats to you?
Yes.
Okay. And earlier you testified that you had asked him basically to confirm that he had said what he did say, that he had intent of having you killed, and we heard him in that state, yes, is that right?
Yes.
It was in that part of the video that we heard that conversation?
Correct.
Was he ultimately taken to the jail?
He was.
And was there any further incident as it relates to this case that happened that day?
No.
During your transport of the defendant, when these threats were made to you, were you in Elkhart County, state of Indiana, at those particular times?
Yes.
No further questions, Your Honor. Stay past the witness.
Mr. Miller, you may ask questions of Sergeant Leeper at this time.
Are you aware of it that you've been sued by me on a prior case, Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana?
No.
I would again object to relevance, Your Honor.
He said no.
Because it's the same or similar question, I'll just simply sustain the objection at this time. You may ask another question, Mr. Miller.
That's all I got.
Any redirect of Sergeant Leeper?
No, Your Honor. Just ask permission to tender Stage 1 to the court.
You may tender it.
Can you imagine an hour-long video?
Thank you very much.
That?
And stay past the witness.
Okay. We already had a cross-exam from Mr. Miller. There's no redirect. I'm guessing you'd like Sergeant Leeper to remain in the courtroom.
I would, Honor.
All right, so Sergeant Leeper, at this time you may step down from the witness chair, but simply remain in the courtroom or the courthouse in case you're recalled.
Okay.
Thank you. Does the state have any other witnesses it wishes to call?
Stay rest, Your Honor.
All right. Mr. Miller, I want to remind you again of your Fifth Amendment right to remain silent. You do not need to testify. You do not need to take a stand. But if you do have any witnesses that you'd like to call, please, including yourself, please let the court know at this time.
I don't.
Okay. Does the defense rest? Is there any evidence that you would like to put on through the form of any witness, whether that be yourself or someone else?
The evidence I've got is that court order, Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana.
Let me stop you there, sir. If you would like to testify, I will swear you in and I'll have you take the stand, and you can ask yourself questions or simply testify in a narrative form, but then you would open yourself up to cross-examination by the state afterwards. So do you wish to testify or do you not wish to take the stand at this time?
I don't wish to testify.
Okay. Do you have any other witnesses that you'd like to testify on your behalf?
No.
Okay, then I will assume the defense rests at this time, and at this point in time it is time for closing arguments. So Mr. Swaby, the state would go first, and you may have rebuttal time at the end.
Thank you, Your Honor. Our burden here today is beyond a reasonable doubt. This is a criminal case, Your Honor, as you're well aware. And specifically, we must prove the elements of intimidation that were charged here, specifically that the defendant made an unlawful threat to injure, specifically in this case, to kill or have murdered Sergeant Adam Weaver. With intent that Sergeant Leeper be placed in fear that the threat would be carried out. There's two parts of that. One, that a threat is made, and two, that we're able to show that there's intent, that he meant it. That he meant for Adam Leeper to think that it was true. And so the state has met its burden here. There's no evidence to the contrary. And what do we have here? We have Paul Miller, who gets arrested on an arrest warrant by two local sheriff officers, both testified before you here today. As he's getting to the vehicle, he's verbally aggressive. He's telling the officers that all officers, including themselves, have death warrants out for them. Maybe a general type of threat, but arguably a threat none the least. At that point in time, officers aren't arresting him on that, but they proceed to take him in on the arrest warrant, specifically Sergeant Leeper. And We heard testimony today, and we saw video confirm the same, the two different threats that Paul Miller made to Sergeant Miller, which was to have him killed, that he was going to have...
I object to that.
On what grounds, Mr. Miller?
I've got a court order, and these guys have been sued. They're sued at the Elkhart Sheriff Department.
Mr. Miller, I'm going to stop you. When I ask on what grounds, I expect you to say something like hearsay, lack of foundation, prejudice, something, some legal grounds. Do you have any legal grounds?
Okay, that would be, that there would actually be hearsay on his part, because he's defending them, and him as a public prosecutor, he's speaking for them, and that sounds like it would be hearsay on his part.
Okay. I will overrule the objection. The state is allowed to characterize the evidence that already came in during the direct examination, so you may continue, Mr. Sir.
It was a good try.
We heard Sergeant Leeper mention, he testified to both of the threats that were made, and the confirmation that Paul Miller, yes, he was going to have Sergeant Leeper killed. We also saw it on the video. And the hardest part in these types of cases generally isn't proving that a threat was stated, but it's the intent portion of this. Whenever truly...
On what grounds, Mr. Miller?
I got a court order with these guys, and I'm not...
Sir, I'm asking for what grounds. I don't want to hear about this other court order.
The grounds would be on information. That information is that court order says they're on execution stay, so I'm not making a threat to them. So on the grounds of information, I've got a court order attached to them. They're in contempt of court, and it's attached to you too. And you've defaulted, and now you've got me in here doing this to me, and that's...
Any specific grounds related to the last statement made by Mr. Swaby?
The information of another case and precedent case, that's the information.
Your objection is overruled. You may continue, Mr. Swaby.
Thank you. The hardest part the state generally struggles with in a case like this is proving the intent. It's hard to unscrew somebody's head and know what they meant, what they were thinking when they made particular statements. So we looked at what was going on, how they were acting, their physical characteristics, their mannerisms, the situation. It's very clear here. This wasn't a joke. He wasn't joking. This wasn't a, ha-ha, I'm going to have you killed, Officer Leeper, you're being mean to me. He meant it. Fortunately, it hasn't happened yet. Sergeant Leeper's still here. There's no doubt. It's very clear from the video. He said it in an angry manner. His voice, his tone. The state's met its elements here today, met its burden of beyond a reasonable doubt. Specifically, that Paul Miller did make the threat on April 19, 2022 to Sergeant Leeper to unlawfully kill him with the intent that Sergeant Leeper believed it to be true. Thank you.
All right, Mr. Miller, you may make your closing argument.
My closing argument is I never made a threat to kill him myself and execute him myself. I have a court order. He's been sued on a prior case. It's Paul Miller versus Kaskaskia Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana. I've got a court order on him. He's on death row stay, and he's on execution stay according to that court order, and I'm not doing it. I'm going to have the Air Force do it. And on the court order, it even states all the departments, the law departments that are liable to do the work. On that court order, it's a court order judgment ex parte notice crime. So that information there proves is the evidence that I have. That evidence itself proves that everything they're doing here today is a lie, it's perjury, according to that court order. So it's court order judgment ex parte notice crime. So you can look at that court order, and you can, Leaper, I know he's been sued. The other guy, he's been sued just as Elkhart Oswald.
Yes, sir.
He might have been sued also, but I know he's stated on a default as a Elkhart Sheriff Department deputy. But I know Leaper's been sued. So for him to sit here and say that I'm going to kill him is perjury. I got a court order on him. He's on execution stay. You can look at that court order. You can look at the default of that case, and you'll see his name there. And it's prior continuing to this. And Oswald, he's been sued also, and that would be prior also. It's he's been sued as an Elkhart Sheriff Department deputy. They all of them have been named. So that's where I'm at on that. It's on that information. I never said that I've got a death warrant on him, because I don't have a death warrant. I've got a court order on both of these gentlemen in here. And they came out there and arrested me with a false warrant that there's a case right declaration in that same case showing that warrant.
I object to irrelevance, Your Honor.
Showing that warrant has been...
I'll overrule the objection. I'll allow it. You may continue, Mr. Miller.
Showing that warrant they brought out to arrest me with was a bad warrant, because according to that prior court order, no other paper can be on me. So with that information, there it is. It's proof. There's live perjury here today. They're saying I made a death threat to them. I'm not making a death threat. I got a court order on both of these gentlemen. They are on execution stay. And I've got it on you also, Mr. Spatero. You defaulted. You can look at that case. No time did any of you answer. So you got me in here, all three of you have me in here saying I'm wanting to kill you. I'm not wanting to kill you. You're on execution stay according to the court order. And it's at Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana. Now,
can someone look that case up?
By that information alone is the proof evidence that you're on execution stay. That court order shows it. And I'm not doing it. I'm going to have the Air Force do it. I used the law, and I sued each one of you. And your name's been, have you looked at that default with your name on it?
At this point, Mr. Miller, I'm going to redirect you to only characterize evidence that came in during this trial.
Okay, so that being said, I've got a court order here, prior court order. You got me in here. And according to that court order, there's stop stay. And you also are. So it is what it is. I've got a court order. You got me in here because they're in I own the Elkhart Sheriff Department building. They took me into the Elkhart Sheriff Department building, outlaw proceeding. They're in contempt of court. And with that information of that prior court order, it's perjury what you're doing to me here today. I've got Leaper and Oswald. I know Leaper's been named, but Oswald, he's probably been named too, but I know I had a default where they were known as Elkhart Sheriff Department deputies, each one of them.
Let me redirect you, Mr. Miller. I'm not going to give you unlimited time on your closing argument. Is there anything that you want to say about the evidence that came in during today's trial?
Okay, my evidence is my court order.
That was not admitted into evidence today, and the trial is over.
Okay, well, I don't need to use it as evidence to admit it into as evidence. It is evidence, so
it was not admitted into evidence in today's trial, Mr. Miller. I'm going to give you one more warning. You've got 2 minutes left maximum. Do you want to say anything about the evidence that came in during today's trial?
I'm just using that evidence as I'm using that evidence as information for what's going on here today. I don't have to put it in as evidence. I'm using it as evidence. So according to whoever's recording things right now, write it down. I've got a court order, Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana. It's known as Court Judgment Ex Parte Notice Crime. It's a court order saying that these guys have defaulted. They're stop stay. They're on execution stay. Spatero, Oswald, and Leeper, all three of them. And that's the evidence I'm using. So that's all I got. And according to what they're doing to me today, that's perjury, because they have no valid court order on me right now. I've got a court order on them already. So right now they've got me in here without a court order, trying to say I'm wanting to kill them.
You've got 30 seconds left, Mr. Miller.
I noticed I said kill, I didn't say murder. So according to that prior court order, they're on execution stay. So just for the record, let that be known, information, that court order, judgment ex parte notice crime, states them on execution stay. They're stop stay. They defaulted in a prior case. And it's known as Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana. That's all I've got.
All right, Mr. Swaby, the state may make rebuttal. I might suggest during rebuttal if you could respond to Mr. Miller's statements that he didn't say he was going to kill, but that the Air Force was going to kill the law.
Sure. Thank you, Your Honor. That is true. That's what the evidence presented. However, under intimidation, it doesn't require that, by the plain words of the statute, it doesn't require that the threat that is made is going to be carried out by himself. Right? So he's charged under Section A4. Person communicates a threat with intent that another person be placed in fear that the threat will be carried out. That's the initial part of this charge. He did communicate a threat. We heard it. That he was going to have the Air Force kill Sergeant Leeper multiple times.
I object to that. It's a valid court order. They defaulted. This guy here,
he is. Sir, your objection is overruled.
He's committing perjury right now.
Please allow Mr. Swaby to speak.
This is a threat. If you look on page 238 of the book, is defined as an expression by words or actions or an intention to, specifically in this case, one, unlawfully injure the person threatened or another person. It further gets elevated to a level 6, which is what we have charged here because of Section B1A, to commit a forcible felony. Forcible felony is defined on page 105 is a felony that involves the use of threat or force against a human being, etc. And so he made the threat here. There's no specific requirement here. It's just that a threat was made, an unlawful threat to injure was made. The officers were carrying out their duties. They had an arrest warrant. They were carrying out their own duties, and he made a threat to have them unlawfully injured, specifically killed, specifically Sergeant Leeper. And so the state has met its burden here today, and that's the court to hold him accountable. Thank you.
Okay, folks, based on the testimony that I heard today, my review of the statute, considering all the evidence, I find Mr. Paul J. Miller guilty of count 1, intimidation, threat to commit a forcible felony, level 6 felony under 35-45-2-1A4. I understand that we have another trial set for this afternoon at 1 o'clock. My suggestion is that we hold off on sentencing at least until after that second trial, if not for another day, to order a records check. I'll ask both sides, but let me start with the state, at least as it pertains to this level 6 felony case. Does the state wish for a records check or PSI to be ordered before sentencing?
I think it would be smart, since sentencing is going to be up to the judge, up to Your Honor.
All right, and Mr. Miller, would you like for a pre-sentence investigation or records check to be ordered before I issue a sentence, at least on this level 6 felony from this morning?
Say that again.
So I have found you guilty, and now the court is in charge of imposing a sentence. Typically, the court will consider aggravating and mitigating circumstances in deciding whether to give a more harsh or more lenient sentence. So typically, we will order either a pre-sentence investigation or a records check before having a sentencing hearing.
You could do the sentencing. That'd be fine if you want to do that.
You're in favor of me doing the sentencing today?
That'd be fine.
Okay, well, I have the state requesting or suggesting it would be beneficial. I have the defendant indicating that he does not have an objection to doing it today. I think it would be wise for me to order at a minimum a records check. And if the PSI is not waived for this felony, I should order the pre-sentence investigation. So what I'm going to do at this time, Mr. Miller, is order a pre-sentence investigation and order you to cooperate with Elkhart County Probation to gather information that I can use in sentencing you. And I'm going to schedule your sentencing hearing, at least on this matter, for a later date that you have the right to have that sentencing hearing be within 30 days. Since you're out of custody, you also have the right to waive that and come back later than 30 days from now. Do you have any objection if I were to go out 5 or 6 weeks by chance? To come back for sentencing in November, mid-November sometime?
That would be fine.
It's fine, okay. Then let me find a date here.
And put the other one in there at the same time.
Well, we'll see what happens. I haven't, the state hasn't met its burden of proof yet for the other case. We'll talk about that this afternoon. But looking at my calendar, I could go out to November 13th. That is a Monday. And Mr. Miller, would you prefer 10 in the morning or 2:30 in the afternoon?
I'd like to put both cases together again.
Okay, and if you're found guilty in the second case, I would do that. Do you prefer morning hearings in general or afternoon hearings?
Morning.
Morning. Let's go with 10 a.m. on Monday, November 13th for sentencing, and we'll specifically show that defendant waives sentencing within 30 days. He's out of custody. He has no objection. We will order the pre-sentence investigation, so probation should be notified. Mr. Miller, you should contact Elkhart County Probation. I can give you a slip of paper with the phone number on it, and then cooperate. They're going to need to ask you questions and put together information for me to consider before I sentence you. And do I have Karen there? Can you confirm, do we have one of those half-page slip of papers that has probation's phone number? We usually, I think there's one on Mr. Swaby's desk. And probation's number, Mr. Miller?
I don't know.
Yellow circle. And you're ordered to contact probation to give them the information they request to put together that pre-sentence investigation. And probation's number is the third one down, 574-523-2203. You can also go down in person to speak with probation in this very building. And I'm not sure, I know I have several law enforcement, several security officers from the Sheriff's Department right here. If you would like to utilize your time efficiently, we don't have the misdemeanor trial until this afternoon at 1 p.m. If you'd like to go with the officers to make an initial contact with probation, you may do that today in the spare time in the middle, but at a minimum, in the next 48 hours, you need to call probation to get the ball rolling on that. Any questions about that, Mr. Miller?
So why do you want me to go to probation?
So the trial that we had this morning is for a felony. And when the court has discretion in deciding an appropriate sentence in a felony case, typically the court will at least ask for a records check and often ask for
I don't want a records check then.
Well, but the state has indicated, at least the wording was, it would be advisable or it might be the right move. So I would like one. And quite frankly, since I haven't had a waiver of the pre-sentence investigation from both sides, I would like to ask.
Well, I don't agree to it. I object to it. I don't agree to it.
Notwithstanding your objection, which I'll overrule, it is court ordered. And you need to either go in person today, or if you're not comfortable going today, you can call them on the phone. But you're ordered to do that.
Just go into person
48
today.
hours. One more time.
Just go in person today.
You can, and if any of our security officers would like to escort you down there, you do have almost 3 full hours before the 1 o'clock trial on the misdemeanor. So if you're in the area and want to do that today, by all means, you can do that. And if you do plan to do that, I might suggest that one of our officers escort you there and take care of that today.
So it's something I walk in and I get taken care of that time.
Well, at least to get it started. I'm not sure, Mr. Swaby, if you have any background info on the types of info they gather, but I know it's an interview of the defendant, and I don't know if it's a series of interviews with the defendant or family members of the defendant. I've seen sometimes family member statements. But at a minimum, you can start the ball rolling by going today, and I recommend that. At this time, folks, I'm going to go off the record. We'll come back for the 1 p.m. trial on the misdemeanor this afternoon.
Thank you, Your Honor.
And we're back. Okay, let's see if we can play this next one here. Round 2. Skipped ahead 3 hours. I'm sure more people got sued during those 3 hours. Little Miss, 14 months with this wonderful group. Thanks for having me and for having the demon puppy. Wonderful to have you, Little Miss. Thank you for your support. We're just waiting for the judge to show up. So, yeah, crazy. I think that's all the cuss counter. I think it's the abbreviated version. That's what we get. But now we have a short case.
Everyone, you may all be seated.
About half the time, this is the misdemeanor trial, and I don't know anything about this.
All right,
it was just posted this week.
This is case of State versus Paul Miller, and this is our misdemeanor case, which is cause number 20-DO5-2205-CM803. I'll show Paul J. Miller appears in person in open court. Mr. Robert Swaby appears for the state of Indiana in person as well. The first thing I want to confirm, as we did this morning, Mr. Miller, is that you still wish to proceed on your own without counsel representing yourself. Is that accurate?
That's accurate.
Okay. And the next thing, it looks like the address that we have of record for you is still the jail, and I know that you're no longer in custody. Is there a different address that you'd like to give us for purposes of mailing notices?
What was that again?
Yeah, the last address of record that we have for you is Elkhart County Jail, and I don't know if you have a different address you'd like to provide for purposes of mailing anything in the future.
One more time?
Yes, what's your current address, sir?
The current address would be
Send it to the Air Force.
516 4650.
Okay, thank you for that. All right. I also want to point out on the question of counsel, you do have a right to be represented by counsel at each and every stage in a criminal proceeding, especially at your trial. If you should change your mind at any time during this trial, Mr. Miller, just let me know by raising your hand or otherwise indicating, and we will have a public defender up sitting next to you in a heartbeat. That being said, Mr. Swaby, is there any opening statement that the state would like to make at this time?
No, Your Honor.
Okay. Mr. Miller, is there any opening statement that you'd like to make at this time? So I know this morning both sides waived their right to opening statement. I haven't heard that Mr. Miller would like to make one. So I'll let Mr. Swaby start by calling his first witness.
State calls Fred Mock.
Mr. Mock, you may come forward. If you please stand before the witness chair and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, you may have a seat, sir. If you would kindly state your full legal name and then spell it for the record, that would be wonderful.
Fred Mock? You want an address to?
Just to spell it for the record, please.
FREDMOCK.
Thank you, sir. Mr. Swaby, you may question your witness.
Thank you. Mr. Mock, thank you for being here today. What do you do for a living, sir? Currently.
Currently, I'm an investigator for planning and development in Elkhart County.
And what are some of your daily responsibilities within that role?
Responding to allegations of local code ordinance violations, building code.
Not a fan of this guy.
Several other county ordinance violations.
Code violations.
And how long have you been in this position?
I've been in this position approximately 4.5 years.
Did you work anywhere before that?
Yes, I did.
And where was that?
I worked for the Sheriff's Department in Elkhart County.
In what capacity did you work for the Sheriff's Office? What was your position? Or
I held several.
Were you a police officer?
I was a police officer. I was a patrol officer. I was a detective. I was an internal affairs investigator, and I conducted polygraphs for the Sheriff's Department for approximately 10 years.
Okay. How long in total were you at the Sheriff's Office?
I served 36 years.
Okay. Sir, earlier you talked about in your current role that you're responsible, some of your responsibilities are going out and investigating potential ordinance violations, building code violations. What does that look like? So if you were to receive, how do you receive a report, or how do you get notice that there's a potential violation that you need to investigate?
Well, planning and development, we're complaint driven. We only respond when a complaint comes in regarding potential ordinance violation. And once that happens, clerical staff prepares what's called a code case, outlining the allegations and the address.
Okay. And then do you receive that you said a code case, is that in the form of a document, or?
Yes, it's a prepared document, a case with a case number assigned to it.
Okay.
And that just starts the ball rolling.
Okay. And then does that given to you?
It is.
Okay. And then that lets you know, hey, this is where maybe I need to go look or go do my investigation?
Yes.
Okay. And for a typical code enforcement, and when you go out to a particular property, what's kind of the general process you do as far as when you're looking for, or you're trying to confirm a violation?
Well, let's use a junk and abandoned ordinance as an example.
Mm-hmm.
I'm given an address, and I'm given what information the clerical staff has gathered, and I prepare myself by taking my camera, mostly a copy of the code case, which gives me the address, and I go out to verify whether or not this is a legitimate complaint. Once I get out there and if I find evidence to support the claim, I photograph and then start the process.
Okay. I want to take your attention back to on or about April 19th of last year, 2022. Do you recall receiving a complaint at an address on 51619 East County Line Road?
I did.
Okay. Do you recall, is that address in Elkhart County, state of Indiana?
It is.
Okay. Do you recall the nature of what that complaint was about?
That was a zoning ordinance violation complaint.
Okay. Do you remember? And it's okay if you don't. Do you remember specifically what type of building or ordinance violation?
The complaint specifically indicated that an individual was living in an accessory building or a shed, and that is prohibited per county ordinance.
Okay. Okay. And do you recall actually responding out to that address?
I did.
Okay. And on this day, you did so in your capacity working, I forget the title you said you are.
Code enforcement investigator.
Code enforcement investigator. You went out there on that particular day in April 19th of 2022 as a code enforcement investigator.
Correct.
Okay. When you got out there, can you explain to us what happened, if anything?
Certainly. I arrived at the address and I driving my county vehicle and observed an accessory building that had been placed on the property. It appeared to be one that was built off-site and was placed on the property. It was a wood-sided,
like tough shit.
And it had an attached over a porch. And I thought, well, this must be the place because there's the accessory building.
Okay. And so what did you do, or what happened next?
Well, I drove my car close to the shed, and as I got closer, I noticed an individual standing on top of a ladder, which was leaned against a tree, close to the accessory building.
Okay. Is that individual in the courtroom today?
He is.
Okay. Can you identify him by stating where he is sitting and an article of clothing that he's wearing?
He's seated to your right. He's wearing a tan-colored shirt.
Your Honor, please let the record reflect the in-court identification of the defendant.
The record shall so reflect.
Okay, thank you. Can you explain what happened next? So you see the defendant on a ladder near this building. What happens?
I stopped my car. I got out and began to photograph the accessory building. The individual on top of the ladder climbed down from the ladder and approached me. There were several obscenities shouted at me. Claiming that I shouldn't be there. He wanted me to leave. He mentioned something about a LaGrange County warrant, but then told me that he had a death warrant for me.
Okay.
And I asked him, what does that mean? And there was no response from him.
Okay. How did this make you feel? What did you do?
Well, not knowing the individual, I didn't know what his intentions were, and it placed me in fear, not knowing what was going to happen next.
And so what did you decide to do?
Well, he continued to shout obscenities to me, and I asked him, do you want me to leave? And he said yes. And as I was getting back into my car to do just that, he mentioned the name Paul Miller. And I looked at him and I said, are you Paul Miller? To which I got no response. And as I was in my car driving away, he continued to shout obscenities at me through the car window as I was leaving.
Okay. And I understand you characterize in a lot of these shouts, these yells that he's directed towards you as obscenities. Do you recall any of the other details of those obscenities, or you state that because it's generally what you remember?
This is what I remember.
Okay. So what did you do after that?
Well, I left. I think I made my way back to the office and reported to my supervisor, who is the building commissioner for Elk Grove County. This is kind of an atypical thing to happen during the day.
Well, that was weird.
Explained to him what had just happened. And,
I think there was a mental evaluation in a previous case.
Doing a bit of research and discovered that Paul Miller had an active warrant for his arrest. And I contacted the sheriff's office to notify them that if Mr. Miller still had an active warrant, then this is where he is if you want him.
Okay. Now, prior to this interaction on April 19th of 2022, did you know Paul Miller?
I'd never met Paul Miller, and I'd never heard of Paul Miller.
Okay. You didn't know him socially outside of work? Never.
I did not know Paul Miller, and I'd never met him before.
Okay. Earlier, you also mentioned that there's a code case that's created that gives you direction as far as to what type of violation there may be and where it's located at?
Exactly.
May I approach the witness, Your Honor?
You may.
There's a copy of it in here. Okay.
So this is how the preceding case came about. Because the lawnmower police ratted him out to the sheriff.
Mr. Mark, hey, what's marked as State Exhibit 1. Can you tell me what that is, if you know?
Yes, this is a code case detailed report, code 0114-2022. The case type is a building code ordinance assigned to me, and then it gives the address.
Is that the code case report that was created for this particular case?
It is.
Okay. And is it a fair and accurate? So earlier, I believe you mentioned that you take a copy of the code case that once it's created, you take it with you to the address. Is that right?
Yes.
Is that a fair and accurate copy of the code case report as you recall it from back in April of 2022?
It is.
Okay. State would move to enter States 1, Your Honor.
Okay. Absent objection, the court admits States Exhibit 1 into evidence.
And permission to tender to the court?
You may tender, you may approach. Thank you.
No further questions, Your Honor. State passes the witness.
Mr. Miller, you are free to question Mr. Mock at this time. Do you have any questions for the witness?
Are you familiar with the case Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana? I've got a court order.
State would object to relevance, Your Honor.
I've got a court order.
I will sustain the objection. You may ask a different question that is related to these proceedings, sir.
I don't have any other questions. That's all I've got.
Okay. Mr. Swaby, any other questions for Mr. Mock?
No question, Your Honor.
All right, then Mr. Mock, you may step down from the witness chair. Does either party desire for Mr. Mock to remain in the courthouse until the trial is over?
State does, Your Honor.
And then Mr. Mock, I'd simply ask that you stick around until we're done this afternoon. Thank you. And Mr. Swaby, the state may call its next witness.
State rests.
Okay. Mr. Miller, do you have any witnesses that you wish to call at this time?
Yes, I do.
Okay, and which witnesses?
Well, it's not a witness. I just have evidence. It's that court order. The judgment ex parte notice crime. It's according to Paul Miller versus Kosciuszko Board of Zoning Appeals, Superior Court 1, Warsaw, Indiana.
Well, the only way that any order or document is going to come in is if a witness testifies about it. So is there a particular witness that you would have to demonstrate its relevance to this case and otherwise testify about it?
Myself.
Okay. And you certainly have the right to take the stand and testify in your own criminal proceeding. However, you do have a constitutional right to remain silent and to not incriminate yourself. So by no means do you need to take the witness stand. If you did choose to take the witness stand to give testimony on your own behalf, you would open yourself up to being cross-examined by Mr. Swaby of the state. Do you wish to take the stand and testify today?
No.
Okay. All right. Do you have any other witnesses besides yourself that you were considering asking to testify?
No.
Okay. Does the defense then rest its case?
Yes.
Okay. At this point in time, then, it's time for closing arguments of each side. Mr. Swaby, I'll allow the state to begin. Mr. Miller, then you may respond, and the state may reserve rebuttal time.
Thank you, Your Honor.
Court should stop
here
him from
today, the
filing
state's
any
burden is
cases.
beyond a reasonable doubt. And although it's the same type of charge here, the elements in this particular case are a bit different than the one previously this morning. The same is proved beyond a reasonable doubt in this particular case, that the defendant communicated a threat, in this case to Mr. Mock, so that Mr. Mock would be placed in fear of a prior lawful act that he had committed. In this case, performing his duty as the code enforcement investigator. Charged under subsection A2 of the intimidation statute. We've only heard from one witness today, Your Honor. It, at this point, is uncontroverted as far as what the evidence is. There's been no allegation, no statements to the contrary. And what we have happened on this particular day is on April 19th of 2022, Fred Mock got notice of a potential code violation that was going on out at the defendant's, where the defendant was residing at the time. Mr. Mock gets out there in accordance with his normal procedures and grabs his camera. He goes to investigate what the potential violation is when he comes across the defendant. The defendant is upset that he's on the property, and as a result of numerous obscenities of which we don't have details on, we know that he was upset and he said a number of different things, but specifically one thing that Mr. Mock did remember and did report because of how abnormal and concerning it was, is that the defendant noted that he had a death warrant out for Mr. Mock. A statement that he took in part made him nervous about what might occur to him, what physical actions, physical harm might come to him. And so as a result, Mr. Mock listened to the defendant, left the property, and subsequently made a report. The state met its burden here today, Your Honor. Again, this is uncontroverted evidence. He did communicate a threat to the defendant, that he had a death warrant out, that it was interpreted by Mr. Mock as potential physical harm to him as a result of him performing his actual duties. The state would ask the court to hold Mr. Miller accountable today and find him guilty. Thank you.
Thank you. Mr. Miller, it's your opportunity to make a closing statement. Do you have anything that you wish to share?
I didn't say that I had a death warrant. What I did say is I have a court order, and it's a court order judgment ex parte notice crime. It's got a thing on there where my security has to be in.
I would, just for the record, I think the court may let him go, but let him continue. But I would object, just for the record, that he's talking in his closing about evidence that wasn't presented in evidence in the case. So the state would just object on those reasons.
I need to sustain the objection and say, Mr. Miller, your closing argument needs to be a summary of the evidence that came forth. There was no evidence other than what Mr. Mock indicated from the stand. And you may choose to characterize it or talk about what it did say or didn't say, but you cannot at this time testify from your table.
That being said, that's all I have to say about it is I've got that other court order and I didn't say anything about a death warrant. So that being said, the place he works at was sued in that case.
Again, I would just maintain the same objection.
The court will sustain the objection that is irrelevant.
So on information, that same information goes, the place where he works at was sued and they defaulted and I got a court order on them.
Okay, I've already sustained the state's objection and I'll again indicate that's irrelevant. You may speak about the evidence that was put forth today and characterize that evidence, or maybe...
I have nothing further to say.
Mr. Swaby, any rebuttal argument?
No, Your Honor.
All right. At this time, in this instance, the court would like to take a brief recess and review the evidence. I certainly heard the witness discuss obscenities. I heard reference to a death warrant. I would like to review the statute and review the audio in chambers, and I will be out shortly yet this afternoon, clearly.
Sorry, I cut that one off. Let me tell you. 45 minutes later, the judge comes out of court, or comes out of his office, and we're going to get the ruling here. Let me actually see if I can get the very tail end of that. That's not pleasant to listen to. Sorry. Um, 16 times speed. His eyes, the judge's eyes, look like they're going to fall out of his head when he does this. It'll only let me go 16 times speed on this one. So we're gonna just skip to the next one. Sorry about that. I didn't mean to cut it off. Thought I'd get prepped and play it ahead of time, but it takes a break. Judge takes a break. Long deliberation.
Okay, folks, you may all be seated. We are back on the record in case of State versus Paul J. Miller, 20D05-2205 CM803. We still have Mr. Miller here in person, Mr. Swaby here in person for the state, as well as witness Fred Mock. The court has gone back and has reviewed the statute, has reviewed the evidence. I listened to the testimony of Mr. Mock again. Before I share my verdict with all of you, I want to let you know I also relied on some jury instructions that we regularly use in this court, and I would like to share them with all of you. One such instruction is, the presumption of innocence continues in favor of defendant through each stage of trial, and you should fit the evidence presented to the presumption that the defendant is innocent if you can reasonably do so. Instructions go on to say, if the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. Further instructions, the evidence must overcome any reasonable doubt concerning the defendant's guilt. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you have weighed and considered all of the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. If you find that there is reasonable doubt that the defendant is guilty of the crime, you must give the defendant the benefit of that doubt and find the defendant not guilty of the crime under consideration. In the single count case before me today, the statute reads as follows. A person who communicates a threat with the intent that another person be placed in fear of retaliation for a prior lawful act commits intimidation, a Class A misdemeanor. Clearly, we have some things that were uttered from the defendant to Mr. Mock, but I listened to and made notes on Mr. Mock's testimony. Some of the things that were stated would certainly not rise to the level of a threat, such as, you shouldn't be here, I want you to leave, I have a LaGrange County warrant against you. The one uttered comment that could come close to the line is, I have a death warrant for you. But even Mr. Mock himself said his response to that was, what does that mean? And that question would indicate that there is more than one interpretation of the statement, I have a death warrant for you. It could simply be a way of a property owner to make someone get off of their property without necessarily intending to cause someone to be fearful for their safety or otherwise. When I consider everything, I come down on the side that I need to give the benefit of the doubt to the defendant, and I believe in construing items that can go one way or another. I have to construe them in Mr. Miller's favor. So with that being said, I find the defendant not guilty of count one. I'll instruct the court to enter a verdict of not guilty, and Mr. Miller, I will tell you that you are free to leave at this time. If either side would like to appeal this judgment, obviously there are 30-day appeal rights. Mr. Miller, I would not imagine that you would want to appeal this judgment, and we can talk about your felony rights when we get to your sentence in the felony case that we handled this morning, and right to appeal from that point on. But the state certainly has a right to appeal this decision if it so desires. With that, we are off the record, folks.
All rise.
All right, and that takes us to the end. So you got a not guilty. Got a not guilty on the misdemeanor. Great work from the judge. You've got to give props to the judge, who was absolutely incredible on that one. The amount of patience he showed, and I have to say, Matthew Harris, he's like, what in the what? We had a case where the only evidence presented, there was no cross-examination, there was no evidence presented at all on the defense side. And the reason why I like the misdemeanor, I wanted to show that one, even though it was not technically spicy, is because there is no burden of proof on the defense side. And the judge looked at the evidence that the prosecution brought, and he looked at the law, and he said, it's not there. I'm not finding it. I'm not finding it. And because of that, we're going to go not guilty. So even though there was a witness that came in and testified against him, charges were brought, it was a misdemeanor. It's a low charge. It's a low bar to commit a misdemeanor. They're pretty easy to commit. I think we've probably committed a couple of them this morning. But Judge looks at it, thinks about it, and says, no, it's not there. Yeah, you might have been concerned, but there was no threat. Just saying I have a death warrant for you apparently is not a threat. So he did work hard, but earlier in the day, he did also convict him of a felony for almost an identical thing that was just caught on camera. So most people commit misdemeanors before breakfast or during, because I have cake upside down in a bowl with milk. So sometimes think that's a misdemeanor. Anyway, fantastic little case. I do think the poor gentleman, I think he's been in and out. If you go through the records, the court records are full of incidents with him. I believe that there was operating with expired plates incident that went on. Let's see, Paul L. also in. Let's see, there was a possible speeding one. Let me find. Go back to the search results. There we go. Limit it down. Let's see, expired plates. There was a speeding. What else do we have on him? I think there's a bunch of failure to use a seatbelt ones. I'm not sure if that's him. Driving while suspended. That's a different guy. Either this guy or somebody with the same name speeds a lot, and it's a common name, Paul Miller. So we'll have to see. Criminal citation. Trying to find the search into the year. It's Paul J. That makes it a little different. Intimidation, threat, and retaliation for a prior lawful act. Intimidation, threat to commit a forcible felony. Arrest without warrant. Miscellaneous criminal probable cause. Arrest without warrant. No charge applicable. I think they let him go. Criminal trespass. Defendant not having contractual interest in property knowingly enters. Arrest without warrant. Bicycle bell or other audible signaling device, sirens and whistles. They cited him for a infraction for lack of a bicycle bell. Disorderly conduct, unreasonable noise, operating a vehicle while intoxicated, endangered in person. Not sure if I think that's a different one. Paul J. again. Reading through a ton of records here. I'm trying to see if we can get to his felony one. Let's see, misdemeanor, felony. Information redacted. Charging. Felony count 6. Hang on, guys. We're doing a little research on the fly here. Felony count 6, according to guidelines, is between 6 months and 2.5 years is the sentence. But those are sentencing guidelines, and guidelines are not hard and fast. So sometimes some states might be able to go outside of that. But I think on this individual, they actually did cite him and order him. There's a court order that he can't file any more lawsuits because he's like the frivolous lawsuit problem. He's just tying up the courts, and so there was a court order where he's banned from doing that. And unfortunately, he does misunderstands the definition of certain words like a stay of execution. I think the court was actually ordering that what he wanted would not happen, and he took that as everyone else is going to get killed by the Air Force. So it was it was a slight misunderstanding. All right, that being said, that was a fun morning. That's a great way to get our day going this morning. Let's see if we can return to some live courts. Let's see, go back to, come on. Is my clicker's dead. We'll charge it really quickly. Clickety click, click, click. Nope, doesn't want to do that. Okay, here's me trying to get all the buttons to make it work, and it's not working. So I'm going to have to get up and... Oh, man. All right, let's see. Let's see if there's something else we can go to. We have... Judge Simpson... Judge Boyd is live. Let's bring her up. Get rid of our map. It's quiet here in the house because Mrs. R.A. Took the kids to a field trip, a science field trip. All right, here we go.
Well, what I could do is you need to go to trial and vote, but let's
What does?
But instead we could not one of the others
Judge is reading some paperwork.
or let's say she's let's just do this. We can put on families. I get an affirmative fine for sure.
Yeah, he meant to stay of execution, but I think it was an execution stay.
All I was trying to say is maybe in a different span of time, I want this stay.
Alvershawn, the motion for early termination you sent me, that's a beautiful letter. Oh, I'm so glad Cassandra did well.
A well-written
I have signed the early termination for her. Yes, and I'm glad the class has helped.
He doesn't get from the two cases he has here. Yes, this is
Give me just a minute. I've got to go unplug and replug in my Apple TV because it's not playing nicely today.
Good morning.
Okay, so that was a stupid me moment. It was an operator error. The Apple TV was working just fine. We're going to jump over to Judge Cedric while we wait for Judge Boyd to get underway.
Ready, Judge?
Oh.
Good to see you. Torso feast.
Wish I could say the same.
I was going to leave it there, Judge.
It's not happy to see people.
I was going to just leave it there.
All right.
Torso feast, the Assistant Public Defender, appearing on behalf of Mr. Kenneth Hall. Judge, I'm texting with the gentleman. My understanding is he's on.
Is Mr. Hall?
Kenneth Hall. Yes.
You're texting with him?
Yes. My understanding is that he's on Zoom, Judge. In the waiting room. Okay.
Okay, so he's texting lies to you.
Apparently, Judge. For the record, I request an adjournment. I don't know what it is.
He's on Zoom in a waiting room. Is he in somebody else's waiting room? You see him in the waiting room?
Oh.
You don't see him? Somebody sees him in the waiting room. Hold on.
All right.
Yeah, I will apologize. He may be telling the truth.
Good.
Shocking. Kenneth Hall, you see him? You have him in the waiting room?
Right here?
She has him in the waiting room. How many waiting rooms do we have? Mr. Childers wants to know.
I'm curious.
We have too many waiting rooms?
Like a VIP one.
Yeah. That's why we were only looking in the VIP one.
Gotcha. No, he's not VIP.
Yeah, it's not good.
Can't afford that now.
Yes, there he is. It's like a miracle. Mr. Hall is here. Oh, Mr. Hall just kind of got here because he's still connected to audio.
Oh, okay.
Let me pass this matter because I don't know when he's going to get her audio. But you text him, tell him.
Figure that out.
Tell him we found him.
Okay. Not in the VIP. Gotcha.
Well, no, tell him he's in the VIP now. He does. Do they have my jail out or no?
Yeah.
Okay. Court does call the case, People versus Jeffrey Long.
Court shows feature Assistant Public Defender appearing on behalf of Mr. Long. How you doing, sir? Please state your name.
Jeffrey Long. Thank you.
Thank you, Judge. I believe we need to stipulate the competency report this morning and set another pretrial date. Yes.
Pardon?
I believe there's
The competency report.
Yes, Judge.
All right. Any other additional evidence either from the people or defense?
No, Judge. Thank you.
All right. They're stipulating to the report. The court would find that the defendant at this time is competent to stand trial. Specifically, the court would indicate upon review of the report that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant's deemed competent.
Thank you, Judge.
I'll need an order to the court, please.
Yes, Judge. I spoke to Ms. Hughes and to my client. I'm going to be doing two things on this file. One is a AIM social work referral to try to see what we can get done there.
Okay.
The other one is an investigation referral to try to see what we have in that area as well. If we could have many PCCs, or we can go out 2 months. If the court will prefer, I'd ask for 2 months. But I just going to take some time.
I can threaten you with having to come back every time, or you can just give us what we want ultimately. Is he in custody on something else, or is this the only thing?
But this is a life offense, Judge.
Yes, it is. Okay. I mean, I'll give you whatever time.
If we can get 2 months.
You want the 2 months?
It's going to take some time to dig into it, Judge.
What would that be?
I have May 16th in our hand.
Is that 2 months out? Or is that by your count?
It's 8
Okay. All right. Wow. You're an attitude.
We appreciate it, Judge.
Probable cause conference, then I will set for May 16th, 2024, 9 a.m.
Thank you very much.
All right. Thank you. Bound continues.
They're all in custodies.
They are.
Yes.
Mr. Hall, your client still, he's got issues.
Still no
Because it's just saying he's trying to connect, so he's doing something wrong.
I'm going to call him.
Okay. You can have Benson talk to him. What is that?
This is set for 9. It's Miss Nicole James. She's not here. Miss James is not here.
Why?
I don't know. I emailed her with no response.
Is the person here?
Sure.
Court calls the case People versus Robin Finney.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of the people.
Robin Finney. Nicole James is on this case. And she's not here either. So I don't know. Well, no, there's a motion to withdraw. Well, no, she was just appointed.
You're at 1 o'clock, so I don't know what you're.
Oh, is she set to be here at 1? On another matter? All right. What I'll do is, this is set in this block, but I'll put this to the 1 o'clock time since they're out of custody. So I don't know why Emily gave me the file. But no, it's okay. It's okay. No, I appreciate your diligence. Court calls the case. People versus Gary Peoples.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of the people.
Bob Prosecuting on behalf of Mr. Peoples, Your Honor. Your Honor, I'm questioning a brief adjournment.
2 weeks due for you. Will 2 weeks work?
Yes, Your Honor.
Probable cause conference April 4th, 2024, 9 a.m. Bond continued. Thank you.
Your Honor, may I approach with the prosecutor?
Man. Yeah, okay. Come on.
Well, I'm waiting this time.
Yes, come on. Come on. Okay, so hold on.
Kills his mic, but you can still see his facial expressions. It's like, what, man? That quick enough? I don't know. You guys keep asking about the outcome from the trial from yesterday. We bailed on it. I didn't see it. I don't pre-watch these cases with you. That we follow. So if you want to go back and see the outcome, there are about 10 more days of trial between the evidence days and the sentencing days. I will say sentencing days because, the defense admitted he was guilty. So we know that he was found guilty, but as far as the sentence goes, I'm not sure. The audio was so very, very bad. Okay, Judge, you back? Doesn't know he's muted. Oh, here we go.
Probable cause in this matter will be April 4th, 2024, 9 a.m.
What date?
April 4th, 9 a.m. Bond will continue. The court may have to take a break shortly, folks. Try to get what I can out.
That was no, it wasn't. She just showed it. I'll show you when you go back.
Okay.
Fill out the rest of it.
I can tell you, I looked it up, Karina, as well. I'll spoil it for everybody since you guys
Court
are
does
asking.
call the case of the People versus Dolores Strickland.
If you do not want to hear what happened in the Stephen Wiggins case, as far as the sentence, because we all know he was found guilty, now's a good time to turn off the sound for about
This would have
30
been a perfect
seconds.
time for me to take a break. Tell her to hold her.
Judge,
Tell her to hold. Yeah, hold that. Court's going to stay in brief recess.
Judge is going to make a mad dash to take a break. While he does that, we're going to tell you the outcome of the Stephen Wiggins trial with terrible audio that we started yesterday and just had to bail on. And that is right here. He was sentenced to life in federal prison. Life in federal prison. So there you have it. That was it. Here, use these. It's too late. I've told everybody. But let's see if Judge Boyd is back yet. She's also taking a break. Apparently everyone takes a break at the same time. Let's see.
If I read this to you in real time?
Yeah, sure. Excuse me. Can you mute us for 1 second?
What? You just unmuted.
Yes.
Looking to see if we have any other courts that are happening. I'm not seeing anything huge. I believe it's no parole. Judges coordinating their bathroom breaks. I think they're calling each other. You'll never guess what I just had. Another pro se. Seems like a busy day in court for Judge Boyd. After the initial sentence, he was sentenced to death in August 2021 by the state of Tennessee. Oh, wow. I think as far as while we're talking about death penalties, I think one was carried out yesterday. And there's another one due to be carried out here very shortly. See, we're getting the update right now. Okay, Stephen Wiggins. This is according to the Tennessean. Stephen Wiggins sentenced to death for murder of Dixon County Sheriff Sergeant Daniel Baker. Defense had put in an argument that because of brain abnormalities, he couldn't be entirely trusted. We reported Wiggins had brain abnormalities, couldn't be entirely trusted because Wiggins lied.
It's Victoria Fernandez. They put her name down and I'll follow up. You sure? Yeah.
Trying to see how the sentencing went down. We got life and then we got switched to death.
Antonio Martinez.
I love them. They're the first pickle flavored.
All right,
I think they're the first pickle flavored
criminal trial division
item that I like that aren't pickles.
This is
that I really enjoyed.
Yes.
And they also have a family case awaiting indictment from about 3 weeks ago.
All right. What is the family violence case?
It's an assault, choking, strangulation.
All right. So where are we on discovery on the drug case?
I've got some more of the videos to get downloaded. We're in first setting today, Judge. I just got to get that to look at.
Okay. But the videos are uploaded?
Kenny,
the
thank you very
videos are
much.
available. There have been some challenges recently getting access to stuff as far as the times. I've just got to make sure it's all there and get it all downloaded to my systems.
Okay. All right. And what is the status of the choking? Is that unindicted and just out there?
Yes, Your Honor, about 3 weeks old, so there's not much in the system present.
All right, Ms. Ferguson, on this case, if I can have a 45-day reset, that should give them time to look into the assault case. If they want to bring you over sooner, then your attorney can just request that. All right, we're going to come back on May 6th, and if you'll give them a reset form just in case he's released. And on this case, is there need to alter and amend conditions to include no contact with the complainant on the alleged new case?
We haven't had any contact with her, Your Honor. I think for now, that would probably be best just for community safety.
And what is the complainant's name?
If you might just give me 2 minutes, I'm happy to
Sure.
go to page.
I'm going to add a condition that there's to be no contact.
Bobby Martinez.
I'm sorry?
Bobby Martinez. No, is it B-O-B-B-I-E? Bobby, B-O-B-B-I-E Martinez. No.
All right, he says it's Bobby Martinez. B-O-B-B-I-E.
B-B-I-E.
B-O-B-B-I-E.
All right.
Martinez.
So, Mr. Martinez, you're not to have any contact with Bobby Martinez. If you make bond and you have contact with her, what's going to end up happening is your bond most likely will be revoked by the magistrate judge. Do you understand?
Yes, ma'am. Yeah, ma'am. Yes, ma'am.
All right, you have any questions?
And just to clarify, no contact means phone calls,
Oh, no,
text messages, telepathic, okay? No contact.
Just let you know, I understand.
Don't do any of this stuff.
I haven't had contact with her.
Okay. Just
Right.
want you to understand.
No
do like
writing of
pickle chips.
letters, no, I'm sorry. Okay,
I already know. That's too, I mean, I already got my words out with it.
all right, thank you.
Thanks, Judge.
Thank you, Judge.
You're welcome.
I already said my piece. Not going to talk to her anymore. Brandon, you did miss both the pro se cases, both the felony and the misdemeanor.
And Adriana, on this one, there's to be no contact.
The jail cuffs are purple.
Bobby Martinez. Thank you.
Officers like to keep their handcuffs in good condition, for the most part, and they sort of, their handcuffs are their handcuffs. They like the ones they have. When the jail transports people, they're using county-owned handcuffs, and no officer wants their handcuffs mixed up with jail ones, and so they do paint them purple to indicate that those ones are the ones that belong to corrections. And no, someone who's asking, no, they're not padded.
May 6th.
Oh, okay. No, I'll do it. Can you give that to Zach and see if he has an idea of a bond amount? Or either he'll be remanded.
Yes.
And everyone, just give me a minute on Mr. Cantu.
It's the key in the shape of a heart. It's the normal key. The normal key.
Thank you, Judge.
You're welcome. Have a great day.
Made a decision, but he's trying to make it really clear.
Okay, no problem.
Individuals also like bodybuilders who have upper body, massive upper bodies. They have a difficult time getting their arms back to close enough that they can put their wrists behind their back, and oftentimes they'll be double cuffed. In that one cuff from one link goes around one arm, The other link goes into another link of another cuff, and then the fourth connection goes around the other wrist. So they've got that space between them. It's still, the people that need that, it still looks rather painful. It looks like a tight fit in the ones I've seen, but ouch. Jim Bob, man. They use 2 pair of cuffs, people who can't get their arms far behind their back. I've messed up the left shoulder, so I would have issues with that. Just got to be polite. Yeah, if you're fighting with the police, they will get your hands behind your back. And it won't feel good. A shoulder might come out, but they won't feel good. The crumbly cuffs were extreme.
Yeah, you can take a break because I have to do this reading of rights, magistrate's warnings.
Okay, so
No
if she's going to
problem.
do that, we're going to jump back to court where we watch. We've got a couple people waiting to deal with or be dealt with by Judge Cedric. I'm going to get out of the way here so you can see everything. There's a fan. Oh, a box fan. That's a new take on things. We haven't seen a box fan before. Miss 19893. Apparently she's not aware this is a non-smoking court either. So, yeah, those box fans, man, I think they should be disposable because it's so hard to clean box fans. Good quality box fans are hard to find anymore. Tell you, if you need a good fan like that, don't shop for them in the regular stores, but go to like Industrial Supply, those places that sell fans for like blowing smoke out of a house. They sell them to like fire departments and things. They have the good fans. They've got the really good ones. I don't know. I think there might be some judges who would allow it, but I think other judges would say, look, act as if you were in the courtroom in every way. We might peek in on Judge Manning. I feel bad for her. I think they still are missing their computer systems. They got hit with a ransomware bug and took down their county computers. So all their courts and jails and everything are just, they haven't had computers for like months. They're running on the bare minimum. So basically you need a fan to clean the fan, right? Or a compressor to clean the fan. My kids love sleeping with fans on. Oh yeah, it's a white noise, which is great, but I think it drowns out my snoring. But also, they just like to sleep cold. Like is that a thing? You like to be cold when you sleep? Reverend Beasy, just make sure it's not plugged in when you rinse it. Softball Mom, our Nevada judges, they do a great job. They've released a lot of great videos, including the one recent one. Is it DeSoto? The YouTuber one? They've got some great stuff. And I'll get a CPAP. First I'm getting plumbing, then we'll look at the CPAP. But hello. I think Mrs. R.A. has a little something to say about the plumbing. She's excited to have that fixed. We're getting really close. We're on the rebuilding stage. Well, mostly. We've got a little more demolition to do upstairs, but the plumbing pipes down into under the crawl space, that is connected, and it's run up to the toilet. The what's it called? The flange is installed. It's all ready. So I've got to do a little demo, then put the new flooring in. We're getting close. I sleep in a wind tunnel. Mr. Kenneth Hall is peering intently at his phone, hoping to make something happen. Judge's got a long break. Usually he starts just a few minutes after the hour for his next block, and he's a little bit late. Nosy Rosa, the kitchen was never affected, so we've always had water, unless we turn the water off. The kitchen water has always been good, and it still has an effective drain. And our laundry as well, washer and dryer, they all happen downstream. Is he in a school? Not sure what we're doing here, Mr. Kenneth. Old houses are fun, they said. Yeah, it's... It's very expensive, I'll tell you that. Old houses are very expensive. The house is beautiful, and I love that when we tear in, everywhere we tear into to do demolition, there's no plywood, there's no pressure treated, consolidated corrugated. There's nothing. It's just high quality. It's just dimensional lumber everywhere. It's just straight wood, and it's heavy. We've got oak and cedar and all sorts of cool stuff. But right now we have one, but it's detached. We have a detached bathroom, so it's like an outhouse, but the outhouse has a 2-bedroom and 1 bath and a kitchen and a family room and a TV and high-speed internet. So it's a really nice outhouse that we've got right now. But normally we have 2 bathrooms. We're just demoing both of them at the same time, which is a terrible idea. Oh, my goodness. Witness explaining how high he was. Reverend Beasy, good luck with your medical help there. Yes, we do have a podcast tonight at 8. Oh, now the judge goes off altogether. What's up with that? Name? Somebody added, after her number, they just put name next to it. They don't build buildings like they used to. Our our house, one of the things I love about it, first of all, it's hardwood floors throughout the entire house. There's no carpet in any of it except for the little entryway that was added on, I think, in the 70s. But the wood, especially in like the front room and the kitchen or the dining room, it has like Greek key inlaid designs around on the hardwood floors around the outside. It's beautiful. I mean, it's old, but it's beautiful. And the stainless, not the stainless, but the chandeliers and the stained glass window in the kitchen, the dining room. It's just you don't find that in houses anymore. Here we go. Come on. Nope. Oh, Kenneth is going to sleep. He's going to be out of it here soon. His eyelids are getting heavy. His phone is tipping over. Struggling to stay awake. You guys, this is how I look, I guess, on camera as well. And he's out. 1, 2, 3. He's down. The snoring will commence. One more little eye pop open for just a second. He can't leave. That's the problem. If he leaves, it's a bench warrant. U.S. sued Apple. Did we find out what that was over? Was that over there? I was waiting to see what it was over. Was it over the store? Name is not entering her name. Oh, centered the camera up. That's nice. I think Kenneth Hall is in like a hospital type setting. Melody, what made you choose the home you are in now? Did you like something in particular? Melody, all I can say is it just felt right when I pulled into the driveway. And I told my wife, she was not here. I saw it by myself before we bought this house. And we had actually played some financial games where we took out a mortgage on our house. We like cashed out our equity and then sold the house and then repaid the HELOC. So we used a HELOC to buy this house, a home equity line of credit, which they don't like you doing. But we answered all the questions they asked us appropriately. We did not hide anything from them. They just didn't ask us what we were doing. And so we basically used the entire HELOC and paid cash for this house because our home had gone up in value so much out west. And then we sold it and paid off the HELOC. So anyway, I came out here without my wife, and I looked at like 9 houses. The first 8 were just terrible, and pulled in the driveway. This one, it just felt right. And I called Jen. I said, this is the one. And I hadn't even been inside yet. And she said, okay, buy it. And I did. It took one click on my phone. I clicked one time, and the deal was done. Then we flew out here. And when we landed, of course, we had sold our car and everything before we flew out. So we flew out and landed. We had shipped all our stuff in a semi-truck to get here. Didn't arrive for a couple days. Landed at the airport, took a rental car from the airport to the first closest dealership we could. Pouring rain. We walked in with cash left over from selling the house, or actually left over from our HELOC, and said, we'd like to buy a car. We got cash, and apparently you can't buy a car unless you're a resident. I'm like, well, I'm a resident. They're like, what's your address? Well, here's my address. Do you have anything on it? No, because I just moved here, but I don't live there anymore. I'm never going back. I'm staying here. It's just day 1 of my residency. And they, I think they bent some rules, but it took like 3 hours and 30, 40 signatures or something to get the car purchased with cash, just a used car to get us to our home. But anyway, fun story. We'll tell it sometime. But as soon as we saw the house, Mrs. R.A. Revoked my house choosing privileges. So next time she gets to see the house before we buy it. Yeah, mortgage companies do not like that. They still don't know. So if you know Bank of America, don't tell them. But it was pretty funny that we were asking interesting questions like, would we be allowed to say like take out all of the HELOC all at once? And so we did. We literally cashed out the HELOC. We're like we wrote ourselves a check, took it to the bank, deposited the money, and when you're moving amounts of money like that, it's like this just doesn't seem right. And then
hello, I don't mean to bother you again, but are we in court yet, or?
Oh, we are. Just calling her lawyer, I think.
We're all just waiting.
Bring the jury.
Maybe Kenneth and this other person could work out their differences, resolve everything without the judge. Closing took 3.5 weeks. Happy to finally make a live canonical. Why can I not say this name? Canonical? Is it canonical or canonical? Heat. Love it. And is it like a lens reference? Is that like a camera reference? Canon? Moved from you know where Hill Air Force Base is? Hill Air Force Base is in Ogden, Utah. We moved from just south of there out to North Carolina. I was working at Hill Air Force Base at the time. I was still working out there when I moved here, which they didn't like either. They said I had to live within 30 minutes of Hill Air Force Base because of the security clearance and my job and everything. And I told them that they would have to find somebody else to do my job then. And they said, you know, on second thought, we'll let you work remote. It's biblical, like canon, like canon, like okay, like a scripture. It's canon. Okay, conical. Nope. Here's the one who would know. Nope. Canonical, if I said that right, in the mathematical sense, reduced to its most basic form. House story is almost as good as the cactus story. Cactus story was wrapped into the house moving. You can't have one without the other. I mean, one caused the other. So. I get the feel that Kenneth thought he could handle this on a break from work, and the break time is over, and now he has to work again, but he can't go back. Just a gut feel on this one. Hang on. My eyes are playing tricks on me. That ceiling fan is mounted to the wall. Like there's nothing underneath it. The cord's hanging straight down, so it's got to be screwed into the wall. Usually box fans are like considered floor fans where they rest on the floor, but this one is definitely not mounted in that configuration. SF in Texas, I did share a cactus story a couple days ago on a live stream. It's a fun little story, and it's true. It's mine. It's about a cactus. And maybe we'll make it into a book one day, or maybe a YouTube short. I don't know. Let's see. Information about the Apple lawsuit. Let's see if we can find this. I need a new burner phone. Or maybe I need to delete old messages. It just won't load new messages anymore. Apple was sued. Apple was sued for intentionally slowing phones to try to force people to buy the newer model. I filled out an online form over a year ago and got a $92 check last week from the settlement. I got the same letter, but I didn't fill it out. I didn't know there was $92 coming my way. I thought it would be like $3. maybe there's. Yeah, I got to check too. All of y'all got paid to get a new Apple phone. I'm trying to look at the backgrounds from the user here, and it looks like she's in a shed. Does that? It looks like exposed studs. No insulation. You've got extension cords on the wall, a fan glued up, and a calendar. Truth be told, says I never fill out those class action lawsuit things. Let's see. Kevin, great place to listen and chat about true crime. Thanks, Scott, for all you do for us. Kevin, thank you for 12 months of support. Congratulations on the Orange Courthouse. Wouldn't be the same without you here, though. Thank you so much. Her fan is like levitating. I'm worried when people are working and doing things on camera where they think they're not live. I'm worried that something will show up that they did not intend to show and that we did not intend to see. Lawnmower police are on the way. See, without her there, you can see I don't see a rack behind it because you can see the whole base of the fan. And that line hanging down from it is the power cord. Maybe she's out in the she shed. Mackie and me. I think Kevin is possibly at a hospital.
Call from Nosy Rosie.
Hey, Nosy Rosie, how are you doing?
I'm well, and I just decided that I would call since we have a little bit of downtime.
Which means the judge will be back in a second.
Interview you.
Oh, you want to interview me?
Well, yes, because we have questions, and my name being Nosy Rosie, I have questions.
Okay.
So, question 1, what made you decide to stream on the day that you started to stream, and had it been a long time coming?
Honestly, it was nearly depression. It was frustration from the job hunt not going the way I thought it would. It was 7 months of looking for work and nothing lining up. I was very picky. I mean, there's work to be had out there, and but there was nothing lining up that met what I wanted, and everything that was available out there would have me moving away from where I thought we needed to be, which is right here. So as far as that very day, it was just, I told my wife, look, I'm going to take a break from looking for a job. You know, I'm just going to do something fun. And I have all this equipment. I like doing electronics, and I just plugged it in, and that's how it started. So it was a long time coming, but I didn't really think it out before it started.
Did you know that it was going to be true crime?
No.
I just went with it.
I had actually, on another channel that I have, I had actually played a game called Farming Simulator online. A gaming, so it's a game where you pretend to do work, which is a little weird.
That's the best kind.
It's literally you're a farmer and you drive around a tractor with a little controller and you plow fields and harvest and plant and fertilize and.
I used to do a game like that. It was Farm Town, and I met a lot of my my Facebook friends that way.
It's a pretty realistic
go work
game.
on their farm.
Yeah, you'd work on the farm, and you'd ask to join a server, and they have all these rules about how many hours of work you have to put in every day, and you know how you have to park the tractor, how you have to wash them afterwards. I mean, it's the realism in that game is through the roof.
I lost countless harvests of raspberries. I never was able to harvest my raspberries in time. 2 hours was too short. Yeah. Okay. So That's how you started. Okay, so a few days ago you mentioned that some high scholars had contacted you about your content and your community, and specifically, we want to know what they were asking about us, and what did you tell them? Yes, we need to know.
Let me go back and look specifically, because the first one that contacted me basically just said, I'm doing like a doctorate level research on communities and how they interact. And they did an analysis of our community, and they were they looked at everything from how, you know, memberships work and how the commands are functioned and who does what, and how there's a sense of belonging in the, you know, being taking a seat in court. And they like diagnosed it to a level. It's like, I felt I'd been laying on some psychiatrist's couch for a week. And it was incredible.
Wow.
It was incredible. And they're like, they basically spelled out why the community works and why it stays what it is and why it's good. I mean, it just...
Did they ask you about demographics? Because this has actually been on my mind, demographics. And I'm like, the community is really close, but I wonder who we are.
They didn't ask me anything. Know. They did the full research without it. Okay, Nosy Rosie, I'll finish the interview after, but Judge is back.
You may be seated.
So call in the next break and we'll do the rest. Okay.
Court calls the case of People versus Stephen Novotny.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of the people.
Edward Drickus on behalf of Stephen Novotny, who was approached.
Your name?
Stephen Richard Novotny.
Thank you. What are we doing?
Your Honor, we're asking for a preliminary examination.
Discovery complete?
To my understanding, yes.
Would the people have their witnesses available the second?
Yes, Your Honor.
Preliminary examination in person will be set April 2nd, 2024, 9 a.m. before me. Bond will continue with its condition.
Thank you, Your Honor.
Thank you.
So Kenneth Hall is at school, I think. You guys are right. That little board behind him.
Court calls the case of People versus Nicholas Martin.
Good morning, Your Honor. Michael Vincent on behalf of Mr. Martin, who is approaching. Your Honor, today's date, time set for a probable cause conference. We need a prelim exam date.
Do you have is discovery complete?
I believe so.
And would the people have their witnesses available the second?
I believe so, Your Honor. Thank you.
Could I check my, I didn't bring this.
I know, I saw you walking alone. So I knew we were going to have an issue.
His assistant helps him so much, especially with technology.
Looks good.
You don't know. All right, anyway. Preliminary examination will be set in person April 2nd, 2024, 9 a.m. before Judge Perry. Bond continues.
Your Honor, my client, which I've talked with Ms. Prosecutor, Ms. Hughes, he's an MMA fighter. He wants to go to permission to go to Las Vegas, April 4th.
He's a what?
He's an MMA fighter.
Wow.
I need all the help I can get.
No, it's okay. Alan, be ready.
Anyways, he wants to leave the state from the April 4th to April 15th.
Any objection from the people?
No, thank you.
Where is he going?
Las Vegas. Baby.
To compete.
Oh, yeah. Sure.
No,
I'm just saying. Okay, that's your story. Stick to it.
Oh. No. He's good. He's won 17 in a row. Hasn't lost any.
You know, me too, when I was young. And that's April
4th to April 15th.
What's his name?
Okay. Defendant is permitted to travel to Las Vegas April 4th through April 15th inclusive. All right.
Thank you.
Just for a second.
Man, he's fighting in court.
Court calls case People versus Dolores Strickland.
Octagon.
2 cases.
And having won 17 in a row, that's a pretty good record.
Judge, Marshall, please, for Assistant Public Defender on behalf of Ms. That's my right at the podium. Ms. Strickland, please state your name for the record.
Dolores Strickland.
Thank you.
Thank you, Judge. Jane Thompson for PCC matter. I am seeking to adjourn this matter for a few weeks to try to see if we can find a resolution. I know that the people have a motion regarding bond that they want to be heard, Your Honor.
All right.
That's correct, Your Honor. Two things from, the first is that new issues will either be issued today or tomorrow for the case for which she came into custody. I expect that to be 4 felonies.
Four felonies?
Ooh, 4 felonies.
Also, I received information that, and forwarded this to the defense, that on 3/6, she left 3 voicemails for the victim, 2 from a different inmate. And in each of the voicemails, she is asking the victim for money. She says, "It's your fault I'm here, so I think you should give my $200. If not, she's going to go down, like hit the fan. I'm done with this shit. Do it. Get me some money on that commissary now, or else I'm going to freak out on you whenever I get that out of here." And we also received information from the victim, this is the DV victim, that she sent her a letter. I got a copy of that letter, which I will need to forward to defense. It's a 5-page handwritten letter, again, asking him for money repeatedly. So I'm going to ask that her be reminded of the no contact order, that her jail call privileges be revoked. And I'm going to ask that his number be blocked with the jail as well.
Obviously, Judge, I don't have the letter yet. I was made aware of the phone call last night. We understand the people's request, and Ms. Strickland apologizes for any violations, Your Honor.
You understand, ma'am, you're not to have any contact with the alleged victim in this case.
I do now, Your Honor.
You didn't before?
Well, we've already been
told you.
We've already been together, Your Honor, as you've seen on camera. The whole world's seen on camera. And we have been together for 15 years. So he also told them that picked it up, the state that picked it up, that he does not want to see me in jail because of it would not do me no good. It would actually make things worse, Your Honor. So
okay, that's fine. You understand you're not to have contact with him?
Yes, no, I did. Yeah, again.
Okay, that's fine.
What date did you want?
We could have at least 2 weeks, Judge. I'm going to look into, I'm going to look into mental health involving Ms. Strickland and determine where we go from there, Judge.
April 4th, 2024, 9 a.m. for probable cause.
Coming April 4th, okay? Mm-hmm. All right. I'll come.
Defendant's bond will continue. Defendant's phone privileges are in the jail are hereby revoked.
Thank you, Judge.
Okay, so she used somebody else's
People
number
versus
already.
Marcus Thompson.
She's still at risk to do that again, right?
Good morning, Assistant Attorney General Emmanuel Wutsa-Coker, on behalf of the people.
Good morning, Mr. Assistant Attorney General. Long time no see.
Yes.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Thompson. Mr. Thompson, will you please state your name for the record?
Marcus Thompson.
All right, this is a waiver.
That is correct.
Mr. Thompson, it's the court's understanding you're waiving your right to a preliminary examination?
Yes, sir.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over circuit court on the single count. Mr. Apple.
Thank you. Defense would acknowledge receipt of the information. We would waive its formal reading and stand mute.
Defendant may waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 29th at 1:30 before Judge Slade Monday.
April 29th, 2024, 1:30, Slay Monday.
Thank you.
Thank you. Bond continue. Thank you.
Assistant Attorney General comes in for that one. Interesting.
Court calls the case People versus Joseph Taylor.
Prosecuting attorney working remote on behalf of the people. 7
Stephanie Hanna with Public Defender's Office.
Your name, sir?
Joseph Tyler.
Thank you. What are we doing?
Your Honor, today is the date and time set for a probable cause conference in this matter. It's my understanding that the prosecutor will be asking for an adjournment in this particular case. It is my belief that there's some additional discovery that has to be collected. In addition, I do believe that we have not received an offer yet in this case.
It is correct. There is additional discovery outstanding.
Probable cause conference, April 4th, 2024, 9 a.m.
Respond on that date, okay?
Okay.
Thank you, Your Honor.
Thank you. Bond, continue. Court calls case People versus Kiwana Hardy.
Good morning, Your Honor. AHB Alex Peterson on behalf of people.
This is Public Defender Hannah Apple appearing on behalf of Ms. Hardy. Ms. Hardy, would you please state your name for the record?
Kawana Hardy.
Thank you. All right, what are we doing?
Your Honor, we are asking for a 2-week adjournment. There was an offer extended that Ms. Hardy is very likely to accept at the next pretrial, but just would like a little bit more time to consider that.
Any objection from the people? Probable cause conference will be adjourned April 4th, 2024, 9 a.m. If your invite indicates, bond continued. Thank you.
Thank you.
Court calls case People versus Leo Watkins.
Really good. Marshall Feaster, Assistant Public Defender on behalf of Mr. Watkins. Mr. Watkins, please state your name for the record.
Yo, John Watkins.
Thank you. Judge, met my client. I spoke to the people. We're asking this matter to be set for preliminary examination. I believe our discovery has been received.
People would have their witnesses available the second. Preliminary examination will be set in person April 2nd, 2024, 9 a.m. That is before me. Bond in this matter will continue.
Thank you, Judge.
Thank you.
Hi, this is Nehemiah Weaver.
Okay.
Hi, Mr. Weaver.
Court calls the case People versus Nehemiah Weaver.
Andrew Tiller, on behalf of people.
Ayden, Senior Assistant Public Defender, representing Mr. Weaver. Mr. Weaver, would you please state your name for the record?
Nehemiah Weaver.
Thank you. That is. All right. What are we doing?
Sorry, Your Honor, what was that?
Pardon?
I'm sorry, I didn't hear what you said.
Oh, what are we doing?
Your Honor, we did approach Mr. Childers with a request for a potential resolution that we will not be able to avail ourselves of at this time. I would ask for an adjournment so that I can have more time to talk to my client about his options. And I believe 1 week would be sufficient.
I can't do 1 week. It's Federal Bureau of Prisons. I think I have to get 4 to 6.
4 to 6.
Wow.
It's 4 to 6 because why?
I'm sorry, what was that, sir?
What are you going to say? What were you saying, Mr. Weaver?
Oh no, I didn't hear you. You said you couldn't do 1 week because I didn't hear the part why you couldn't do 1 week.
You'll have to speak up. We're having problems hearing you. But
I didn't hear the part where you said the 1 week part where you couldn't do 1 week.
Oh, we have to serve a writ on the Federal Bureau of Prisons to get you at this proceeding. Ms. Gaines asked for 1 week, and the timeline for the writs for the Federal Bureau of Prisons are 4 to 6 weeks. So I was just informing Ms. Gaines of that.
So he has to sit for another month.
At this time, so I'll put it clearly on the record. At this time, we have requested a misdemeanor resolution given what Mr. Weaver's sentence is in the federal facility. Counsel indicated that they were not willing to offer a misdemeanor, that if Mr. Weaver waived preliminary examination, they would look at a concurrent sentence in the circuit court. So that, Mr. Weaver, with that information, would you like to waive the preliminary examination, or would you like for us to continue with this adjournment and discuss the case more?
I would like to waive it if they will offer a concurrent one to my federal sentence.
Okay. So, Mr. Weaver, you understand that you're waiving your right to a preliminary examination. That is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, our client wishes to stand mute and have a court enter a not guilty plea.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for, and we're going to give a date. It might be moved, but because of the writ issue.
April 9th at 1:30 before Judge Cumbie.
April 9th, 2024, 1:30.
Thank you.
Bond will continue. All right. Thank you, sir.
Thank you.
All right. Thank you.
I'm ready. What do we have to do on that?
I'm still looking at the MMA stuff, trying to find this fighter. Nicholas Martin.
Oh, he was supposed to get some other stuff. Okay. Yeah, I'll see him. I'll get him out. That's their last one?
Yes.
Court calls case People versus Victor Hayes.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of People.
Ron Brown appearing on behalf of Mr. Hayes.
Good morning, sir.
Your Honor, we referred him over to the sobriety court, circuit court. He was ill and missed that appointment. I'm requesting another adjournment. Preschool.
Okay. I think with the other one, we set the 11th and hopefully.
Please.
They can do that. Probable cause conference, April 11th, 2024, 9 a.m. Bond continued.
Thank you.
Right, thank you. Feel better, sir.
Follow up.
Court recalls case People versus Maurice Jones.
On behalf of the people.
Joy Gaines, Senior Assistant Public Defender representing Mr. Jones. You had requested verification that Mr. Jones was scheduled for a substance abuse evaluation last week, March 14th. Mr. Jones was in fact scheduled. I was able to obtain verification showing that he had an appointment on March 14th at 12 o'clock noon with the testing agency, pardon me, with the assessment agency.
Okay, I see that, but and they won't see him.
That is my understanding from Mr. Brown. That's the agency. That's one of the agencies, according to Mr. Brown, that 14.
When was he set for sentencing?
I want to say April 23rd, or was it the 22nd? April 23rd. Yeah.
He was. No, I know when he set this time, but when was he? He was going to do the assessment. When was he set for sentencing after that assessment?
23rd. So in about a month.
We would turn this out to the 4th. All right.
I'm still trying to find this guy's page. Is he fighting in UFC 300, or it just happens to be down there for some other competition at the same time? Now I know I shouldn't type it. I don't see Navante on the cards.
Well, never mind.
I saw it set.
Becca thinks it's Nicholas Martin.
Defendant having admitted to the violation, I'm not going to give him a straight PR. He'll need to set the appointment. I'll let him out prior to sentencing. I'll sentence him on that on the violation of 28 days. I'll give him credit for 21 days. So I'll serve an additional 3 weeks. He should get it out in time then to do his assessment and then properly be sentenced before Judge Freshour.
Right. Thank you.
Nicholas Martin has a 1-1-0 record, win, loss, and draw. This guy is supposed to have a 17-0 record.
And this is said he's set to come back on the 4th, but he's to remain in custody. Well, he'll be in custody because he's got to serve the contempt. Thank you.
Thank you.
Court calls the case People versus Dominic Hemingway.
On behalf of the people.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Hemingway.
Dominic Hemingway.
Your Honor, this time we're asking the court to set the matter for preliminary examination.
Discovery complete.
Yes, Your Honor.
People have their witnesses available the second.
Yes, Your Honor.
Preliminary examination, April 2nd, 2024, 9 a.m. That is in person before Judge Harry. Bond, continue. Thank you. Court calls case People versus Mason Hendricks.
Andrew Bannis, Assistant Public Defender, with and on behalf of Mr. Hendricks, who's
Mason Hendricks.
I have a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading no contest. Do I have a report? I do. No contest to the charge of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There's further the agreement, no delayed or deferred sentencing.
That's both my and my client's understanding of the plea offer.
Understand it as well. Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear in the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Mason Hendricks.
Sir, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. Is that correct?
Yes.
That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about a no contest plea I have to make sure you understand. The first thing, it means you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
Basis for the no contest plea?
Potential civil liability, and I believe lack of recollection also, Your Honor, to some extent.
To the charge of attempted resisting and obstructing, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
Well, you have to answer it. There's no sentencing agreement, for example.
No.
No, but, sir, do you understand? Has anybody promised you anything to get you to do this?
No.
Other than what we said on the record, that counts 1 and 2 would be dismissed. Has anybody promised you anything else?
No.
Has anybody threatened you or coerced you in any way to get you to plead?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Like crazy.
Yes.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 246234. Any objection to the court having reviewed that report?
No objection.
No objection. Thank you.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be April 4th, 2024, 1:30 before Judge Balvo.
Awesome. Thank you very much.
Bond continued. Thank you. Court calls case of the people versus Bilal Howard.
Mr. Howard, please state your name for the record.
Bilal Howard.
Thank you, Judge. We're still trying to get a resolution in this matter. If we can just have a short adjournment, hopefully we can get this resolved.
Probable cause conference April 4th.
Thank you, Judge.
2024, 9 a.m. or as your invite indicates, bond continued. Thank you. Court calls case people versus Lakita Johnson.
Portia, please to Assistant Public Defender on behalf of Ms. Johnson. Ms. Johnson, please state your name for the record.
Lakita Johnson.
Thank you, Judge. This time there's no offer on this file. We're trying to get an offer on this file. I'm going to put together a mitigation letter. If we could have about 4 weeks, that'd be greatly appreciated.
4 weeks for a letter?
Well, it's going to.
Fine. No, that's fine.
He's a slow typer.
It's hard when you write slow.
Yes, Judge.
Probable cause conference April 18th. 2024, 9 a.m. or as your invite indicates, bond will continue. Thank you, baby. Court calls case people versus Anthony McFarland.
Andrew Turner on behalf of the people.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. McFarland.
Barlin, thank you.
Your Honor, we are requesting some additional time to discuss Mr. McFarland's case.
So you're seeking an adjournment?
Yes, please.
April 11th, 2024, 9 a.m. or as your invite indicates, bond continues. Thank you.
Thank you.
Court calls case people versus Kimberly Nelson.
Warren Green on behalf of Ms. Nelson.
Kimberly Nelson.
Thank you.
Thank you.
Your Honor, I had a discussion with Ms. Nelson. At this time, she wishes to waive her right to preliminary examination and proceed to circuit court.
Is that correct, ma'am?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 30th at 1:30 before Judge Company.
April 30th, 2024, 1:30. Bond continued. Thank you.
Thank you, Your Honor.
Yes, sir. Court does call the case, people versus Lee Parker.
Can I put Senior Assistant Prosecuting Attorney for the people? Ready to go, Judge?
Portia Feaster, Assistant Public Defender on behalf of Mr. Lee Parker. Mr. Parker, please state your name for the record.
Lee Parker.
Thank you, Judge. We were here a couple of weeks ago trying to get verification that Mr. Parker has been accepted into 34th District Court's drug court program. He has been accepted. I think he will start that program next week. So if we can go out for 2 weeks to verify he's began, that'd be greatly appreciated.
April 4th, 2024, 9 a.m., or as your invite indicates. Bound continue.
Thank you, Judge. So make sure you follow up with that.
Court calls case People versus Michelle Cobbleflesh Blessing.
Andrew Childers appearing on behalf of people.
And Alex Warren Green on behalf of Ms. Codfleesh Blessing.
Ma'am, can you state your name, please?
Michelle Cowflesh Blessing.
Thank you.
Your Honor, today's date and time set for probable cause conference, asking the court for a lengthier adjournment. We're working with the 81st District Court, who has a drug court program. I know Ms. Cobb Blessing's already spoken with the coordinator at that court. So for purposes of resolving this case and getting her into treatment, we are hoping to get her into that court.
And Your Honor, the people are also filing an amended charging documents, adding, we've been waiting on some lab reports, so we're adding a possession of methamphetamine as well as a operating while intoxicated third offense. This is not a surprise. We knew these reports were forthcoming. So those should be prepared in the next few days and filed.
Okay. Why don't I do this then? So we can get everything together. I'll just adjourn the probable cause to April 18th. (9 a.m. or as indicated. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, ma'am. Recall. Court recalls case People versus Kenneth Hall.
Ready again, Judge. Torture Feaster, Assistant Public Defender, appearing on behalf of Mr. Kenneth Hall.
Andrew Childers appearing on behalf of the people.
Last I checked, he was on Zoom, but we could not hear him because of audio.
He didn't connect to audio, so he wasn't fully on Zoom.
Okay, fair.
Is he in the waiting room now?
Not the waiting room for the VIP waiting room.
So he's in neither. So, gee, Feaster, where's your client?
He was on Zoom, Judge. I don't know where he is now. I know he was Zooming, or he told me he was Zooming from work. I believe he's working in Grand Rapids, he indicated. So
that's in a different time zone, right?
No.
Oh, okay.
I'm just trying to answer.
No, I didn't know what your excuse was going to be.
No, he is at work in Grand Rapids, and he is not here, but he was here. And so based on him attempting to Zoom in, and me going to be requesting for an adjournment anyway, I asked court to consider.
Oh, you were going to request
I was, Judge. I was.
He's not here. So I'll tell you what. Why don't I pass it again? We'll call him up in the next block, see if you can get through to him, see if you can get him on Zoom.
Thank you, Judge.
Get him here. I'm sure we'd all like to talk to him.
I appreciate it. Thank you.
That's it for that block. And then I got a 12 o'clock block coming up.
Yes, sir.
And it's just after 12. I'm going to take a brief recess. We'll come back out. We'll start the 12 o'clock call. First ending recess.
All rise.
So Michelle, I'm not sure if she knows she can leave. Isn't she done?
ABC.
The court is located in Michigan. Yes. It's now just down to us and Michelle. Okay, she's done. She's gone. All right. Let's see. Judge Boyd is still up.
Did disclose some information on probably why he's doing the drugs, and he provided documentation, medical documentation that from an illness that he is suffering from right now. That he was just released from the hospital last week. I would like to do a felony drug court referral, and I would like to also for him to enroll in intensive outpatient treatment.
You want to do felony drug court in custody or out of custody?
He just got a job, Judge.
Okay, where are you working?
County Woodsby, downtown here.
All right, so what do you do there?
I'm front desk, night audit.
Okay, so I tell you what, based upon what probation is telling me, I can change my mind. I believe in communication. She's informing me that there are some medical issues. Plus, she's informing me that you just have employment, but you have got to stop using drugs. Otherwise, one or two things going to happen. It could be the last time you use, and somebody will have to identify your body, or you're going to end up in prison. You understand?
Yes.
All right. So this is what we'll do then. We'll do a referral to felony drug court. It'll be out of custody. Are you okay with me sending them an email, or would you
Yes,
send
sir.
them? All right.
I was gonna reach out to felony drug court as well, but your emails always help. I would also like to point out that Mr. Borer has been reporting on time, so I don't have any doubt that he'd actually report for his appointment with felony drug court.
All right. So, Mr. Borer, I'm not going to take you into custody today, but you need to make all of these appointments. You understand?
Sure.
And you should thank probation, because I was going to put you in custody, but I keep an open mind. When somebody tells me, hey, judge, you didn't consider this, I will consider it. All right?
Yes, sure.
Okay. All right. So we're going to have you remain in the court, though, so that we can give you the contact information for felony drug court. And here's the thing. Whenever you think about using, if it's Monday through Friday, we're here. You can always come in here instead of using and let me know, hey, I'm thinking about using. What should I do? I'll tell you, of course, to call your sober support person or get in touch with felony drug court. Don't just use and throw your hands up, because, again, it could be the last time you use and you could end up having somebody identify your body. You understand?
Yes.
We don't want that. I want you to be successful on probation. So just have a seat. I'm going to send this email out, and hopefully they'll have a space for you in felony drug court. Okay? All right. All right. I'm sending the email now. Okay.
That's a great opportunity. It's risky.
Okay.
It's risky. There's a lot of responsibility on his shoulders to make the right choice, where previously he hasn't been. He must have done something to impress, or at least make the prosecution, the probation guys, inclined to give him a chance as well. So he's got to be putting in some effort as well. Judge Boyd has invited so many people into her courtroom. Some people she's ordered into her courtroom, but others she's invited in, saying, "Hey, just come down here. I'm here. We're here." And I think that's something they need to hear. That, and I believe honestly that she means it. She's like, I want the best outcome for you, and if that means it takes more time out of my day down the road when you come in and say, "Hey, I'm struggling," I'm okay with that. I'll be here for you. You can come in. We can talk. I mean, yes, this is a courtroom, but I'm here for you. I literally, it's what makes her amazing. She's
all right.
really
But
cool.
Sean, if you just have him wait here until I get the email back. All right. So, guys, I always do compliance hearings, and it's just to make sure that people are on track. I don't immediately issue motions to revoke unless there's a reason for it. And sometimes I'll make a decision on something, and then I'll get more information about it, and I'll change my mind.
She has interns or
And I believe that you should always have an open mind and listen to everybody. So since probation told me what his issues were, and I read the compliance hearing report, that's why I decided not for him to be in custody while we await that evaluation. Okay? All right, if you're returning that back to the Sean. All right, who's here on David Vargas? David Vargas? Thank you. Good morning. How's it going? Yeah. All right. Are you ready to proceed?
Well, Your Honor. That one. Oh, there he is, Your Honor.
Yes.
Okay. What were you talking about, Your Honor? We're ready to do the pleas on the three we were hoping to do the sentencing at a later date.
All right, oh. And why are we doing sentencing at a later date?
So we can get everything together on it. It's going to be contested sentencing.
Okay,
If you'd like us to do the pleas today, we're more than ready to do that.
all right. We will do the plea today and then we will set it for sentencing. Court is calling 2018 CR 5087, State of Texas versus David R. Vargas. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael Dwight wants to defend.
Are you Mr. Vargas?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? You need to speak up?
Yes.
Are you the same David R. Vargas who's placed on deferred adjudication in 2018 CR 5087 for the offense of aggravated assault with a deadly weapon on August 6, 2019 for a period of 10 years? Is that you?
Yes.
All right, state.
Violated condition number 1, on or about the 20th day of November, 2023 in Bexar County, Texas, defendant David R. Vargas committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated condition.
Oh, we're having a contested hearing?
Your Honor, the next two will carry.
Ah, okay.
Violated condition number 1, on or about the 20th day of November, 2023 in Bexar County, Texas. The defendant, David R. Vargas, committed the offense of driving while license invalid in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 2, on or about the 20th day of November, 2023 in Bexar County, Texas. The defendant, David R. Vargas, did then and there consume alcoholic beverages in violation of condition number 2.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violations 1, the driving while license invalid, and violation number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 1 and 2?
Yes.
Then the court will find violations 1 and 2 true. And we will set this for my decision on, Norma, if you can set this the second week in April.
Judge, it's going to be contested on that date as to the driving while intoxicated.
Okay. Since it's going to be contested, Norma, put it the third week in April. All right, we're going to come back on April 15th. Happy tax day.
Under the judge portion.
Wow. Happy tax day.
All right, just give him a reset form and then he's excused. Bashan, on this case, April 15th. All right. And so contested hearings means that the state is going to bring in evidence. Yes. Yes.
It's not going to be contested on the 15th, Judge. I was confused. I'm sorry.
All right. So it's not contested.
It's just going to be for sentencing, Your Honor.
It's just for sentencing. All right. Thank you. Matthew Hughes. Matthew Hughes, who's the attorney? Just have a seat. Sarah Wilson.
Attorney is not there, so Matthew gets to sit and wait.
Hello. Good morning. All right. Good morning. All right. So was an offer tendered?
It was. My client informed me this morning that she wants no longer wants me to be her attorney.
She wants to talk.
So I was just approaching on a withdrawal issue. The offer was tendered and refused.
All right. If you want another attorney, you'll have to hire one.
Oh, yes, ma'am. And I do have the paperwork already.
No, I mean, you'll have to hire an attorney. So have you hired an attorney?
I have to hire one. I can't just get another.
No.
And I do have one in mind.
No, you need to hire an attorney. You can't choose who you want to represent you if you're not paying for that attorney.
No, ma'am. I didn't say I wanted to choose. I just wanted another court-appointed lawyer.
No, you court-appointed attorneys?
Yes.
This is your court-appointed attorney. If you want a different attorney, then you will have to retain or hire one. That's how it works.
I wasn't aware that that's how it worked. I thought we could just get another court
No,
appointment.
No.
People do it all the time.
not in this court, they don't. All right, so we need a plea deadline date, Ms. Ferguson?
That's today. We're just set up for trial.
All right, Ms. Ferguson, need a jury trial date. This is an ag assault with a deadly weapon, 2 days. It's 2 days for trial. No, they already have that other case that's set. You think it's, all right, we'll put it on April 22nd. All right, April 22nd. That will be your jury trial date. Thank you.
Thank you, Judge.
Attorney's like, I told you. I tried to tell you, but you wouldn't listen. I tried to tell you.
Who's here on Darianne De La Rosa? All right, come forward.
Matthew, you're licensed in the state of Texas. This is your chance. Go in there pro bono.
Jerry, yes, Jerry, it's like Jerry and.
She's not going to be able to pay, I don't
Are
think.
y'all ready to proceed?
Yes, ma'am, we are.
Court is calling 2023 CR 4230, State of Texas versus Darianne Renee De La Rosa. Could I have parties announced for the record for the state? Defense?
Charles Golden.
Are you Ms. De La Rosa?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Darianne Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a term of 5 years? Is that you?
Yes, sir.
State?
Yes, Your Honor. Violating condition number 56, on or about the 30th day of January 2024, in Bear County, Texas, the defendant Darianne Renee De La Rosa, then and there failed to comply with the rules and regulations or instructions of the Bear County Supervision and Corrections Department's duly diagnosed residential facility, and that the defendant refuses to participate with the required program violation number 56.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of 56, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition 56?
Yes.
Court will find it true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And is to keep the individual on her probation and defer to deny the motion and alter and amend the required her to attend safety.
Okay, why is she not going to DDRF? That's my question, because that's what I ordered.
The information that we received from DDR was she did not want to participate.
All right, so you can participate at the prison, but it's not going to be at Safe-P. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there. So what's going to end up happening, you've been here before, the court is going to find you guilty. Now, how much prison time do y'all want to ask for?
Judge, the state originally maybe requesting 5 years, Your Honor.
I would ask for 2, Judge. She's willing to go to Safe-P. She wants to continue with drug court. We would ask that you reconsider and consider Safe-P. We understand that's going to be 9 months long with aftercare. She's willing to do that.
Okay, this is what the court is going to do. As previously stated, the court is finding violation of 56 true. The court will find you guilty. There is to be no contact with Monica Tobias. Court is going to find you guilty. Court is going to sentence you to 8 years in the prison. Court will give you credit for any time served. Court will retain jurisdiction.
Thank you, Judge.
All right, I'm showing you what's entitled, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right. Because this is not a plea bargain agreement, you do have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you are on probation. Do you understand? All right, we can go off the record. So, Ms. De La Rosa, when you're sent to certain programs, I'm not just doing it because, hey, let's just do this for no reason whatsoever. There was a reason you were sent to that program. You do not get to write your own programs. If you could write your own program and be successful at it, you wouldn't be in court. You would be successful. All right, good luck to you. Jesse Arriaga.
That was a surprise to her. She didn't realize that the hammer would fall, and it did.
All right, on this case, we're here for discovery on a forensic interview.
And they are coming by today.
Okay.
Yes, Your Honor, we have an appointment for 1:30.
All right, so were you able to tender an offer?
Not yet. I think they wanted to finish doing it, and then once kind of we're all able to be more or less on the same page, Your Honor, at that point, we'd be willing to make an offer.
All right, Ms. Fergus, can you recall this in 3 weeks, please?
Thank you.
All right, we're going to come back on April 15th. On April 15th, the state will be prepared to make an offer.
Absolutely. Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
All right, thank you.
Your Honor, may I ask, the bond hearing on Mr. Lozano, he has been brought out. Do we just put the file up there and?
Yes,
Do it
once the
online?
file is up
Okay.
here, then I'll take care of that.
Okay, I've got it queued up to get a soundbite. This is not Burger King. You don't get to have it your way. I like that one. Man, but I need to delete one of my sound bites that I have stored. Let's see. No.
Joshua Patillo.
What's the trees one?
Don't miss the forest for the trees.
I'm going to delete that one. I think you guys can still have access, but I just won't be able to queue it up myself.
All right. So the sanity evaluation was completed. Where are we?
Judge, I think that there's a couple of things. I believe that we probably need some sort of finding by the court, or I'm thinking that my client, I haven't discussed with him, but we
Your
may
client
need
is a giant.
trial
The
on
guy's
the
huge.
issue of the sanity. I know, it's just.
I haven't
Well,
talked to my client yet, but I think
that's
he's
one thing.
insane.
I'm gonna set that aside. Most pressing thing is.
Don't know how to bring this up because he's a
this
giant. He's
morning,
standing right next to me.
And I did receive the report, by the way, and I have reviewed it. I need to discuss further with my client the sanity issue. So I need some time, and again, because of his mental health issues, it takes me a little bit longer to have those conversations. The other thing is, there's two
Bailiff, move
large
closer.
banker's boxes of his cases in discovery in here in the courtroom. There are two large packets of what looks like additional discovery that did not look familiar to me. I don't think that the state is, given the voluminous amounts of discovery, I don't think that the state's going to be able to verify very easily what's been uploaded or not. And our solution that we discussed this morning is that I am going to provide them on Monday, I think is the soonest I could probably get it done, with a hard drive so they can just put everything on there and for every one of his cases. And
Judge, the plan is I'm gonna look through the file, any disk, I'll upload it so that she can say, this is what's been uploaded. I'll also put the electronic discovery that we have so that she can see what's been uploaded already.
the problem is we both have separate numbers and identifiers for everything. So it's very difficult for us to sit down and go, oh, okay, you have this, you have that.
All right, so Norma, on this case, this is going to be set for a final discovery on April 30th. And before that time, with regards to the sanity issue, that needs to be sent to Judge Carruthers, and it needs to be heard before April 30th.
And Judge, I think that Norma, if you could double check that I know that I am out for most of April, so I'm not sure if I'm back on the 30th.
I think this man's beard needs its own court date. That is substantial. We haven't heard the charge on this one. A lot of times we don't hear it. We
Okay,
have to dig through
perfect.
the
Thank you.
docket.
Thank you so much.
You're welcome. Adolph Lopez.
AZDCS Oversight Group, welcome to the gallery. Thanks for your continued support. 4 months. 4 months of support.
And everyone, the court is recessing exactly at noon, so you need to start moving with a purpose and a plan.
Does she have a jury trial today?
All right, court is calling 2020 CR 8725, State of Texas versus Adolph Lopez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Will Brooks for the defendant, Mr. Lopez.
And are you Mr. Lopez?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adolph Lopez who was placed on deferred adjudication in 2020 CR 8725 for the offense of obstruction or retaliation on January 26, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 48, on or about the 22nd day of February 2024 in Rusk County, Texas. The defendant, Adolph Lopez, did then and there fail to comply with the rules, regulations, or instructions of the state contracted intermediate sanctioned facility in Henderson, Texas, in that the defendant was unsuccessfully discharged from the treatment program in violation of condition number 48.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 48, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 48?
Yes, ma'am.
Court will find violation of condition number 48 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you adjudicate the defendant guilty and sentence him to 2 years in prison.
All right. Why should I sentence him to 2?
So, Judge, a couple of reasons. As far as Mr. Lopez goes, there's a period of time where he was incompetent in the state hospital for 8 months or so. He is on his meds at times and off his meds at times. I know that the charge itself is retaliation, and there's allegations that he's being not compliant with the staff there at ISF. He spent approximately 94 days there, so nearly finished off the program, Judge. I think his biggest threat is to himself, Judge, in spite of the charge, if that makes sense. He is someone that does suffer from mental health issues. He is competent to proceed today, but I think based on the court initially granting him deferred for 3 years, I think that smacks of the circumstances probably of the retaliation, the amount of time that he's been in custody. I think it's just would be a travesty to incarcerate him for longer as someone that suffers from mental health issues.
All right. So here's my concern. He's here for retaliation. And I know based upon the length of probation that he was given, it's retaliation, but there are mental health issues going on. My concern is that if I revoke him, because it seems like people are trying to head towards a judgment satisfied, he's going to end up with a judgment satisfied with no supervision whatsoever. He's just going to be out there roaming.
With no treatment.
He has a plan in place, Judge.
What's the plan?
He's going to go live with his brother. I've asked him about how he's going to get his medications. He plans to go to Center for Healthcare Services to continue treatment. He takes Prozac. He's currently receiving that in custody. I do understand the court's concerns.
Would felony drug court accept him?
I don't know if there's any space at all right now, Judge. I can certainly talk to them. If the court's inclined to continue him, I think part of the problem is that he's just fed up with being incarcerated for so long at this point. He sat for ISF, yeah, it's a process and it's difficult. Sometimes it's hard to work on your issues when you're confined like that. So if the court would consider giving them outpatient treatment, and I'm more than willing to talk to felony
The
drug
state's
court.
asking for 2 years
All
in
right,
jail,
Ms. Abrams,
in prison.
on this case, Mr. Lopez, what are you all suggesting or recommending?
I think they're requesting
It appears
incarceration.
that they may be tired of working with you. And have they addressed some sort of plan about what he's to do with his rest of his life? Because then we'll have somebody who's out in the free world with no supervision, and he has these mental health issues.
Yeah, but if I can get this a couple of minutes to look over the case.
Okay. All right, just have a seat and we'll see where we are.
The judge doesn't want to send him back to jail. Yes, he
I
violated
don't know if you
parole,
want to call
but with mental health,
them and see if they can take him.
she's saying, look at
I
felony
just had
drug court.
somebody FDA this morning that was supposed to sign a packet, so I'm
Oh, yeah.
probably.
And, but don't let him leapfrog, Mr. I think I sent another person over there to Borja, who's sitting right here in court. Oh, you're here. Maybe you can talk to him about the program. Look at me, just making stuff happen. Oh, let me see.
The guy just like pushed his way through.
Oh, yes, I did. They're going to screen him ASAP. So I'm going to forward this to you, Ms. Abrams. And if you can see where they want him to meet them. Good morning. Sure.
I just got a motion to travel. State is unopposed.
Oh, just give it to them. Juan De Jesus. Oh my gosh, this is bad.
There's another soundbite.
Norma, we're going to reset Mr. De Jesus. When do you want to bring him back? And it's probably need to be. Yes, we can. Deputy Laura, would you let Mr. De Jesus know that his attorney can't be present for medical reasons?
Ooh. That's what she's talking about. It's bad. The situation with his attorney is bad.
Everyone, De Jesus, Juan Carlos De Jesus, it's being reset for April 22nd. The attorney broke several ribs.
Oof. The worst part about that is like, how do you fix that? You just don't aggravate them, but it hurts. Every time you breathe, it hurts. Broken ribs are bad. So I hear. Not as bad as I'd say like with the collarbone, but you can't cast a rib.
Ron,
Yes.
what did you do with the bond reduction paperwork that I gave you yesterday?
Who is this for?
This was for Laquisha Cyphers.
Did you throw it away?
It should be in the back. Yes, they should have it. Jesus Lopez.
If you break ribs, do not have allergies. Don't sneeze, Chris. That's right. Don't sneeze for sure. Breathe, cough.
Court is
sneeze,
calling 2023 CR 8930, State of Texas versus Jesus Lopez. Could I have parties announced for the record for the state?
Daniel's part of the state, and Judge, I believe that you're gonna have to set this for contested. Defense wanted to provide some documentation to the state regarding one of the violations.
Yes, Judge, this case was transferred to Nueces County, and the violations allegedly occurred down there. And I need to get some medical records. He missed an appointment because he was sick. And I need to get my hands on those.
All right, the motion has allegations of possession or purchase of tobacco.
He apparently has a lawyer down there. I don't know anything about those cases other than what the charges are.
All right, Ms. Ferguson, recall this in 3 weeks for a contested.
Contested, meaning he's not
And
going
it's
to plead guilty
Jesus
to the
Lopez.
parole violation.
And I understand, Judge, he doesn't have a bond set. I need to file a written motion. Is that?
Yes.
Then I'll do that.
All right, we'll come back on April 16th for a contested hearing.
Thank you, Your Honor.
Who's here on Keith Hunt? All right, so did he make bond?
Yes, Your Honor.
Okay. Because I had issued a judge's warrant and remanded him without bond. So who gave him a bond?
I think this was the date I was not here, because I was on trial. And so someone stepped in, don't recall who it was, and approached the court said bond, we'll make the bond. And then it was set for, I think, a week and a half ago, because you were on trial. It was reset for today. So he's currently on bond. He has no warrants.
Judge is like, I said no
No,
bond.
the reason why I set a judge's warrant with no bond is because there was a violation order of a no contact order. And if there's a violation of a no contact order, I would not then set a bond.
Well, I don't have, I was on trial in another court. The case was set that day. I actually tried to get it reset, but it wasn't able to. So he came, he was taken into custody. And then someone, I don't have the name, but you asked someone to stand in for me at that point. And they, I think it was from legal aid. And they got a bond, requested a bond from the court set a bond. And then he bonded out the next day. And it was reset for today.
All right. So where are we on discovery?
We should be in good order, Your Honor.
Did you tender an offer?
We have tendered an offer.
How old are you?
I'm 30.
All right, Ms. Ferguson, set this in 2 weeks for a plea deadline date. And do you understand what no contact means?
Yes.
There's to be no contact with the complainant. You don't call the complainant. You don't ask the complainant how they're doing. You don't send a birthday card. You don't send a thinking of you card. None of that. You don't say, hey, let's get back together. That relationship is over. If you have contact with that complainant, what's going to end up happening, I'm going to keep an open mind, and you have the potential of having your case heard while you're in custody. Do you understand?
Yes, ma'am.
All right. What date? All right, April 8th. Once you sign the reset form, you're excused.
So Your Honors, I have like 10 cases set April 8th. Could we do it April 9th?
All right.
April 8th is Monday. And so
Let me see. Norbert, put it for April 1st. All right, your plea deadline date is April 1st.
Thank you, Your Honor.
Thank you, Judge.
You're welcome. Once you sign the reset form, you're excused.
Thought she was going to revoke the bonds, take him into custody, but apparently she was the one that issued the bond. It was just in another lawyer situation. Hey, Mrs. Ari is back.
All right, who's here on John Meyer?
I have, Your Honor. Come on up, Ms. Meyer.
Yes.
Where do I stand? Oh, on this side.
All right, what's happening on this case? What are you asking for?
Your Honor, we're ready on Monday. I think Mr. Wilkins is too. We just wanted to get an idea of, I'll let Hank explain.
Judge, we're set for a sentencing on Monday, and I think we were trying to figure out, do you want us, is that at 9 on Monday? And is that, I'm planning on bringing witnesses.
How many witnesses?
4 witnesses.
All right, Ms. Ferguson, this is set on Monday. They're going to have witnesses. Can we do this in the afternoon? just speak to Ms. Ferguson because he's not on the docket today, correct?
Yes, ma'am, that's right.
All right, so if you speak to her, but we'll keep it on the same day. She'll just give you a time.
And if we do that, is it okay? Remember, Mr.
He can
Baird,
appear by Zoom if he wants to appear by Zoom.
He'll want to
attorney.
He'll want to be here also, but
Yes.
just want to make sure I'll get him here whenever we're set, right?
Yes.
1:30.
1:30. Yes.
Thank you.
All right, who is here on, are you already on Adolph Lopez or not? All right, thank you. Is the attorney here for Matthew Hughes?
Yes.
Come on, Mr. Hughes.
All right, where are we on discovery? It's Matthew Hughes.
Yes.
Have you received all the discovery?
Yes, ma'am.
No, I mean, have you received all the discovery?
Everything that's on e-discovery, I have access to. If there's anything outside of that, then I'm not sure.
All right, State, were you able to tender an offer?
Yes, Your Honor.
How old are you?
I'm 25, Your Honor.
All right, Ms. Ferguson, can you recall this in 3 weeks for a plea deadline date, please?
3 weeks to think over the plea deal.
All right, your plea deadline date is going to be April 15th. On that date, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, Your Honor.
All right, see you then. Once you sign the reset form, you're excused. Thank you.
Josh, this is great news. Let me take a look at this. Saying there's an update on the Idaho prisoner escape, the manhunt. The name and photo of his accomplice has been released. It's harder to hide two people than one, so let's see what we have here.
All right, who's here on Edward Garcia?
That is me, Your Honor. Eric Holt. Great.
Yes, come forward. Court is calling 2020 CR 4575, State of Texas versus Edward Garcia Jr. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Eric DeWalt, representing Mr. Edward Garcia.
And are you Mr. Edward Garcia?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and First Amended Motion to Enter Adjudication of Guilt. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Edward Garcia Jr. who was placed on deferred adjudication in 2020 CR 4575 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on February 22nd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 1, on or about the 15th day of February 2024 in Bexar County, Texas, the defendant, Edward Garcia Jr., committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
State?
Oh, sorry, Judge. The state waives all the other violations alleged in the motion.
Any objection?
No objection found.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find condition number 1 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you adjudicate the defendant guilty, revoke the defendant, and sentence him to 4 years in the prison.
Ooh.
And what's happening with the number 1?
He's going to go plea to the number 1 because it's evading, Judge.
All right, defense. Are you asking the court to follow that agreement?
We are, Your Honor.
Mr. Garcia, are you waiving your right to appeal?
Yes, ma'am.
All right, probation, is that your recommendation, revocation?
Your Honor, probation's recommendations for state ISF cognitive track, followed by supervision by the ISP unit.
All right.
Or revocation. Oh, or revocation.
Does that work?
Sorry.
All right, Mr. Garcia, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Edward Garcia Jr.
All right, why have you not been successful on probation? What's going on in your life?
I have been struggling with finance and transport.
I don't know. So you can strike the finance part out of it because that doesn't mean that you pick up new cases. Financing has nothing to do with you committing a new offense. So what are you planning on doing with the rest of your life?
Trying to get off probation, you know.
No, I mean,
The rest of my
you're
life.
going to get off of probation. I'm going to revoke you. I'm just trying to figure out what are your plans so the citizens of Bexar County don't see you back here again committing a new offense. So what's your plan for your future?
Just finding a successful job and staying out of trouble.
All right. And the court notes that this is not your first motion to revoke with this court. All right. The court is going to find you guilty. Court is going to not grant you community supervision, sentence you to 4 years in prison. And was there any restitution in this to the clerk? This file doesn't have his affidavit of admonishments in it.
I apologize.
All right. I'll give you credit for any time served.
Thank you, Your Honor.
Judge, I can see restitution for lab fees.
All right. Did you pay your laboratory fees?
No, ma'am.
All right. Do we have an amount in the file?
$60.
All right. Restitution of $60. And who would that be to? Who would the restitution be to?
According to what we have here, I believe it's SAPD.
All right. There's to be restitution of $60 to SAPD for laboratory testing.
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Did he ever do ISF or no?
Well, did you ever the ISF Applewhite?
Did he successfully complete that or no?
It was unsatisfactory for ISF, but he did also attend SATF and safety.
All right. Well, did he successfully complete SafeP?
Yes, Judge, I believe so.
All right. I'll give him credit for any time for SafeP, but I'm not giving you credit for ISF because it shows that you didn't successfully complete that.
Yes, ma'am.
So credit for any time and SafeP. All right.
We're going to do a quick
Judge, can we
update
have
here about the
defendant
Idaho
take down
case.
Court 6 to the
Just a
there?
second.
You need to talk to the deputies. Is there anything else with regards to sentencing from either side?
Nothing from defense, Your Honor.
All right. Just one moment before he leaves. What room are we in, Diana? Okay. Just
We're
one
in the
moment.
courtroom, Judge.
Yeah, and you know what? It's not opening for me. Oh, wait a minute. I'm in there. Just 1 second. I wanted to make sure that I told him about his gun violation because I was trying to do 3 things at once. Oh, not to have any possession of any weapons. All right. I see, according to the records, I told you about that. All right. Here's the thing. You're going to have to change your life. Otherwise, you're going to be in and out of somebody's prison and in and out of somebody's jail. If you don't want that to be your life, then you're going to have to change. If you have an issue with drugs, alcohol, whatever it may be, there are plenty of programs that can help you with that. Otherwise, you're going to wake up because time passes by quickly and half of your life is going to be gone. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
Thank you, Your Honor. May I be excused?
Yes.
All right, we're going to take a quick break here. I think the judge is about to break
Sure.
because she's
Just give me 1 moment.
minutes away from. I think
Jacob Bruno.
she's almost done.
I'll take that up next after this.
2 more.
All right, court is calling 2023 CR 7267 and 2022 CR 8044, State of Texas versus Tyrone Laird. Could I have parties announced for the record?
Judge, that's
the next one.
Wrong case.
Oh, my gosh, I thought it was the same one. Hey, you know what? Sometimes you got to slow the train down. Ah, okay. Court is calling 2023 CR 7267, State of Texas versus Jacob Roland Bruno. Could I have parties announced for the record for the state? Defense?
Todd Coronado.
And are you Jacob Roland Bruno?
Yes, sir.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Could I have a file stamp, please? Motion to revoke.
Okay, he's going to get revoked. We're going to bail on this one just a little bit. We are going to show you this. We got an update out of Idaho right now. So this is the missing person case that's going on. New blue alert. Yesterday we had this was an unknown individual. A lot of question marks there. So we're going to see if we can zoom in just a wee bit on this. Come on. Where's it at? Why does it not let me zoom? Come on. There we go. Now we can zoom. All right. So our initial suspect that escaped, that was incarcerated, is this gentleman right there, Skylar W. Mead. I use the term loosely, gentleman. Looks like he had a rough day in prison. I think this was probably why he was in the hospital getting treated. Maybe. I'm not sure, but he's got product of my enforcement, chest tattoo, stomach says AK. His cohort, and this we believe is the individual who goes by the name of Moose, or the nickname of Moose. We believe this is the person who initially shot at the police officers to enable them the escape, and we have an Idaho plate number too. 2 Tango Delta Delta Foxtrot 43 uniform is the plate number. So now we have a gray Honda Civic with Idaho plate that we're looking for. Moose is 28 years old, male, white, 5'9", 160 pounds, also bald, and hazel eyes. No relation. Umphenor and Mead. But they believe they are an imminent and credible threat to law enforcement and or the public. Individuals are considered armed and dangerous. Please do not approach, but call 911 or this 208 number for tips, 208-377-6790. That's the Ada County Dispatch, by the way. So that's the update. So now we've got 2 people to look for. That means it's twice as easy to catch them. If you're in the area, see a gray Honda Civic, especially with that plate, or a couple bald guys in it, that's enough. Just call a blue alert. This is a blue alert is because the officers are in danger. This is a threat to officers. It's we've got amber alerts, we've got blue alerts, because these guys the first guy was already in jail for an attack on an officer. So, yeah. That's Idaho right now. So Rocky and Bullwinkle spinoff, says Nikki. Yeah. The Honda Civic is in the midst of us all. There's Honda Civics everywhere. Like every 5 feet, you're going to see a Honda Civic. Umphenor and Mead sounds like a wacky kids cartoon. It's an interesting mix of names. Randy, I'm just saying, what are the odds the 2 bald guys are going to be in a Honda Civic with Idaho plates? Pretty high, but if you see it happen, you might as well call the police. You never know. You might save a life. In Texas, we have silver alert. So silver alert is like an amber alert, but usually it's with somebody who's a little older and possibly suffering from the effects of age and need assistance or help. If they catch these guys, or if they find these guys, when you hear felony stop, it's going to be like we're gonna hold them at gunpoint until the Bearcat arrives, and then we're going to mace them and tase them, even if they're complying. It's gonna be a rough situation. Plus, officers just don't take nicely to somebody who's, shot at some of their coworkers. All right, we're going to take a lunch. Judge Boyd's taking a lunch, or is about to, and then we'll come back and do some more court hopping, because some fun cases start next week. We think we might be able to follow, so we'll see where we go there. What did you do with the paperwork, Judge? I love that. That was funny. Oh, before I forget, because I will forget if I don't do it right now. I have to turn on the sound. I'll forget if I don't. See, there's the sound right there. That's me. I didn't realize I was also live myself. We're going to play this really quickly so I can get a sound bite.
She did not want to participate.
All right, so you can participate at the prison, but it's not going to be at Safety. This is not Burger King. All right, so you can participate at the prison, but it's not going to be at Safety. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there. So
let's see if my first attempt worked. Let's try it.
This is not Burger King. People do not get to have it their way.
There we go. First attempt was perfect. So now we're going to load that up. And during the lunch break, I'll get together ready. I think BK is going to be the command for that one. Oh, no, we can't do that because that's Brian Koberger. What would be the way? 6? I think that works. BK is good, but I don't want to be confused with Brian Koberger, because that case is coming up. BK way. I can't have it say Burger King on there. King? B King? What about King? King seems like a good name, and I'm cool with Way, but I think King might be a better name. Okay, we'll make King during the break, so that should be up and running when we come back from lunch. I'll do it as soon as we break. I promise. Or Burger. Burger works really good. Man, I like that better than King. Whopper. We could just say Whopper. So many options. I don't know which one I'm going to choose. All right. Thanks for the fantastic morning, you guys. We've had a lot of fun. We've had some court hopping. We've also had some pro se defendants. We had a twofer with a pro se. We had that this morning. We've had some updates on some big cases. The Rust case, the document drop. I can't wait to hear what you guys find in those documents as you peruse through those. Now I want burgers, not McDonald's. Whopper is good. I like Whopper. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be in about an hour and 10 minutes. I'm not doing any plumbing during lunch break. I'm taking the lunch off, so I'll work on that later today. All right, guys, enjoy your lunch. We'll be back with more court hopping and fun and general mayhem after this. So have a good one. We'll see you after. Bye.
This is not Burger King. People do not get to have it their way. This is not Burger King. People do not get to have it their way.